Right, good morning, everyone. All right, let me go back to main jail, okay? Sorry, can you all hear me in the main jail? Just wave your arms around if you can hear me. Oh, wait, now I can't hear you, so hold on. There we go, now I can hear you. Good morning, sir.
Good morning. How are you, Judge?
I am great. Can you please tell me your name, sir?
Sure, it's Mike Farberic.
Oh, Mr. Forbear, good morning.
How
Long
are you?
time no see. Good to see
Long
you.
time no see. Good to see you as well.
Okay. Good morning, everyone. My name is Judge Florence Taylor Barner, and I'm going to be the judge presiding over the first appearance docket this morning. I'm going to start with a couple of ground rules. First and foremost, if you can't hear me or if I'm talking too fast, please tell me. It's okay to tell me that. Also, if you start talking about the facts of your case, please understand that I'm not trying to be rude, but I am going to cut you off because everything that you are saying is being recorded. And there is a state attorney, meaning the prosecuting attorney, is sitting right there in the courtroom. So that is why I'm going to cut you off if you start talking about the facts of your case. I am not trying to be rude, but again, that is the reason for that. But that stated, when you hear your name, please approach the podium. All right, and we'll try to make this as pleasant an experience as we can this morning.
Your Honor, there is one case that the main jail has requested be called out of order.
All right. Oh, yes, and if I can please have the parties announced for the record, starting with the state.
Eric Linder on behalf of the state, Your Honor.
And
Brian
defense.
Reedy, on behalf of the Public Defender's Office.
All right, good morning. And tell me, who is it that we need to call out of order?
He would be on page 7 of your docket, Judge. The name is Emmanuel Okwar, O-K-W-O-R.
Your Honor, I'm going to need to request that this matter be kept on recall.
Okay, give me 1 second. Let me just find it first. Okay, I do have it. Okay.
Your Honor, may I approach?
Yes, please.
Thank you.
Do you need me to go on sidebar? Good. Okay, I'm sorry, sir. If I can just have you, Mr. Okor, if I can have you have a seat for 1 moment, we're actually going to call your case back up momentarily, okay?
Judge, also, just so the court knows on Mr. Okmar, he indicated he has private counsel, Michael Gottlieb.
Okay, great. Has Mr. Gottlieb been notified?
No, I just heard about that for the first time, Judge.
All right.
I will call Mr. Gottlieb, though.
Thank you very much. So we'll go ahead and contact his lawyer for him. Thank you, sir. All right, so we're
Judge,
going to...
the jail just notified me while we were sidebar that on page 16 of the court's docket, they also need a Mr. Lionel Beaumont called out of order, B-E-A-U-M-O-N-T, fairly close to the end of the court's docket.
All right, so let me find that. Close to the end. Nope, that's not it. Maybe I went too far down. Found it. Lionel George Beaumont. All right, good morning, Mr. Beaumont. How are you today, sir? All right, Mr. Beaumont.
Get back home to my kids.
Okay, I understand, Mr. Beaumont. Good morning, sir. Like I said, sir, you're here today for a probable cause determination, sir. The charges are 1 and 2 counts of petty theft, sir. The court does find probable cause after reviewing the probable cause affidavit, sir. Is this a misdemeanor? No, these are felonies. Okay, so I can't resolve your cases this morning. However, if you are able to bond out, sir, you are not to return back to the Circle K. State what says you has to bond.
Your Honor, I'd be requesting that the bonds be kept in place. Mr. Beaumont has pending possession of cocaine that he is before Judge McCarthy on.
Is he out on bond on that case?
He's actually ROR'd. He was picked up, he was on pretrial. He violated pretrial based on a new resisting without violence arrest. He ended up being ROR'd at a later date on mid-August of this year. Additionally, he was arrested and pled out a misdemeanor theft November 14th.
All right, sir, the court's going to leave your bonds in place as is. As to count one, the bond will remain at $750. As to count two, $750 for a total, sir, of $1,500. You are not to return back to the Circle K, okay?
Okay,
Your Honor,
Judge,
the-
the
Your
only
Honor,
thing I would ask, Judge,
there's
Yes,
also
Mr. Linder.
The second thing, the second theft allegation involved a Publix. I didn't know if the court wanted to order no return to that Publix.
So ordered. You're also not to return back to the Publix where you were arrested, okay, sir? And yes, I'm sorry, Mr.
no problem, Judge. Judge, he had indicated to me, and I'm just asking the court if the court would do this. He's not sure that he can afford the amount of bond that the court set. I understand that he has other issues that are out there, but he was only asking the court if the court could reduce the bond to $500 with regards to count one and count two. He does have family members that live here in the area that would probably be able to post that bond for him.
State?
That's fine, Judge.
All right, so ordered as to count one and count two, the court will reduce the bonds from $750 to $500 each, for a total of $1,000 bond. Again, sir, you are ordered not to return back to the locations of your arrest. Do you understand?
Say it again. Say it again.
Yes, ma'am.
All right, thank you, sir. Have a great day.
Thank you, Judge.
There we go. All right, anybody else I need to call out of order?
Not to the best of my knowledge, Judge.
All right, so why don't I do this? I'm going to try to go in docket order as I can, although I do have some members in the audience. Mr. Farberik, would it be better for you to call the folks who have the members in the audience here?
Judge, it depends on where they are, because at some point they cut off the docket. There are some people still in the back.
Gotcha, so,
It'd be better to go down the docket.
all right, we'll go docket order. That's stated. Christina Marie Sarsour.
Main jail, she's on her way up.
All right, good morning. Someone is here for you, ma'am. Good morning.
Good morning.
All right, sir, there's a gentleman who's here in the audience. Sir, can you tell me who you are?
James Jones from out on bail bonds.
I'm sorry?
A bail bondsman. James
Oh, you're the bail
Jones.
bondsman.
Yes,
Okay,
ma'am.
good morning, sir. How are you today? Thank you for coming in this morning.
You're welcome.
Ma'am, your bail bondsman is here. All right, ma'am, you are charged with one count of aggravated assault with a deadly weapon in terms of domestic violence. Count two is the same. The court does find probable cause to detain you. Ma'am, you are, number one, ordered to have no contact with the alleged victim in this case. Do you understand?
Yes.
Secondly, you are to not possess any weapons, including any firearms. Do you understand?
Yes.
All right. Now, what says, okay, yes, sir. Anything you want to tell me?
Yes, I spoke with her mom, Miss Elise, and she's only able to afford probably $1,000 on each count, which is an amount of $200 bond.
I'm sorry, I need you to
Okay.
speak up.
I said I spoke to her mom, Miss Elise,
Okay?
and she's only able to afford a total of $2,000 bond. Just
Oh.
200.
Okay, Mr. Farberik, I don't know if you heard him. What he was saying is that he spoke to her mother. Her mother is only able to afford $2,000 in bond. State what says you has to bond.
Your Honor,
Correct, Judge.
she only has misdemeanor priors. I was gonna be requesting a $2,500 bond on each count. This does appear to be ongoing violence, frankly, between both parties. I know the alleged victim in this case is also,
On the
appears to be
docket as well, I
docket.
read that.
Yes, so,
All right, that's stated. I'm sorry, what were the priors? Are they anything recent?
it's, not that recent, and they're misdemeanors, nothing related to this, Your Honor.
All right, ma'am, remember I said, don't say anything about the facts of your case. Remember, I was gonna cut you off if you tried. All right, that stated, the court is going to set your bond, as to both counts in the amount of $1,500 each, for a total of $3,000 in bond. Like I said, ma'am, you're to have no contact with the alleged victim in the case, okay?
Okay.
All right, good luck to you, ma'am.
Judge, just so you know, that the reason there's a little bit delay in their response, I turned the mic off because sometimes.
It's really hard, no, I understand. I got it, don't worry.
All right.
And Your Honor,
Yes.
I'm also here for, page 13.
Page 13.
Should be in the book.
Lung Chang.
Judge, he's in the back, still up in the, yeah. They're gonna pull him from the back, if you give us 1 second.
Take your time.
Back here.
All right.
All right, let me find his paperwork while I'm doing that. Actually, I know where his paperwork is. It's at the end.
Yeah, this is the phone.
All right, hold on. Found this. Okay, hold on, I got Mr. Chang. Okay. Where'd he go? Shall I call someone else in the interim? Why don't I do that? How about Amber Wright?
Medical reset.
All right, we'll reset that case. Cycloria Williams.
Medical reset.
Okay. Shardrika Ponder.
North Broward. Ms. Ponder would like to resolve this matter today if possible.
All right, good morning, Ms. Ponder. How are you today?
I'm doing fine.
All right, good morning, ma'am. You are charged with 1 count of resisting an officer or obstruction without violence. You're also charged with violating a municipal ordinance. And also, ma'am, you have an open case it's an MO, which means it's a city case. You have a misdemeanor capias.
All my charges
Ma'am,
was
just
thrown
don't
out last
hijack.
year when I went to court.
Hang on.
Hang on.
Did you hear what I said earlier about I was going to cut you off if you start talking about the facts of your cases? Yes. The reason I'm doing that is because your lawyer is standing here in court, okay? Let him do his job. Sir, please announce for the record.
Hi, Judge. Steve Plant. I'm here on the city cases.
Good to see you, Mr. Plant.
Likewise, Judge.
All right, so Mr. Plant,
So she could resolve as well with the state, or she could go to community court, which would be
what are her priors?
convenient.
Well, you know it's me for community court.
So we should probably, I would,
As far as
see.
Broward, battery, resisting without violence,
When was the most recent battery?
2012.
Okay.
she could resolve.
Or she can resolve her case.
Right.
Yes. Is there an offer to resolve?
Well, it's, the same, time served.
All right. Ma'am, Ms. Ponder, did you hear what the offer was? The offer to resolve your case would be an adjudication, court costs, and time served. Do you wish to resolve your case?
Yes, ma'am.
Okay, what about the other case? Because she does have a status on the other case, the other MO.
It's just, also, she could resolve that, Judge.
Would you like to resolve your other case as well?
Yes, ma'am.
Say it'll be the same
Do
thing?
the same offer on the state charge as well, Your Honor.
All of your cases, including the state charges, looks like it's your lucky day. They're willing to offer you an adjudication, court costs, and time served. Want to take it?
What's time served, ma'am?
Means we're giving you credit for the time that you've already served in the county jail.
Yes, ma'am.
All right, so that stated, please raise your right hand. Ma'am, do you
Ma'am,
swear,
we're not-
listen, do you
You're not
swear
helping
or
yourself.
affirm that the testimony you're
ma'am.
about to give this morning will be the truth, the whole truth, and nothing but the truth to help you?
Yes, ma'am.
All right, ma'am, you can put your hand down. Please state your full name for the record.
Shardrika Quantrell Ponder.
Okay, how far did you go in school?
11th grade.
Okay, have you ever been treated for a mental illness?
No, ma'am.
All right, are you under the influence of alcohol, narcotics, or any other medication?
No medication, but I do have a beer from time to time.
I mean, right now. Right now, are you under the influence of anything? Right? Well, I would imagine you would be sober right now.
Yes, ma'am. No beer, no nothing.
All right, that's what I'm talking about. Okay, everyone articulate the terms of the plea. State, city.
adjudicate time served, Your Honor.
All right. Have you, do you understand the terms of the plea? The adjudication, court costs, and time served?
Yes, ma'am.
All right, have you had an opportunity to discuss the terms of the plea with your lawyer? That's the gentleman here in the courtroom.
Yes.
Okay, has anyone promised you anything other than the terms that the court just told you?
He said that I could,
No,
Answer
no,
the question,
wait.
I
Don't,
forgot the word.
okay, listen. Don't tell me about what the conversation between you and your lawyer. Just, has anyone told you you're gonna get anything other than an adjudication and court costs and time
No,
served?
ma'am.
Okay, that's the question I'm asking. All right, is anyone forcing you or threatening you in any way to accept the terms of this plea?
No, ma'am.
All right, do you understand that there will not be a trial if you accept the plea?
Yes, I understand.
Okay, and then do you understand that if you accept this plea, you'll be giving up certain constitutional rights, not forever, just for today, for the purpose of accepting the plea. And for everyone else's benefit, I'm going to read the entire list so you can hear me refer to this again. All right, you'll be giving up the right to plead not guilty and to have a trial by jury, the right to an attorney or to have the court appoint one for you if you cannot afford one, the right to remain silent and to not incriminate yourself, the right to have the state prove you guilty beyond a reasonable doubt, the right to confront witnesses against you and to cross-examine those witnesses, the right to defend yourself by calling witnesses and presenting evidence, and the right to appeal the conviction and sentence to a higher court. Do you understand those constitutional rights as I have explained them to you?
Yes, ma'am. I
All right.
understand.
Do you understanding those rights, ma'am? Do you wish to proceed to a trial with those rights, or do you wish to waive those rights and accept the plea offer?
I wish to waive the rights and accept the plea offer.
All right, ma'am. Do you understand that if you are not a United States citizen, that this plea will subject you to deportation?
Yes, ma'am, I understand.
All right. And also, do you understand that entering in this plea may cause your driver, well, hold on, not this plea. Have you had enough time to discuss the case, any possible defenses in the plea with your attorney?
Yes, sir.
Sir.
Yes, ma'am. Yes, ma'am.
All right. See, I'm just making sure you're on your toes this morning. Also, now, are you satisfied with your attorney's representation?
Yes, I'm satisfied.
Is there anything else that you want your attorney to do to defend your case that he hasn't already done for you?
Remember, it's yes
That'll
or,
be all.
All right, thank you, ma'am. All right, everyone, having reviewed the discovery in this case, do we all stipulate that there's a factual basis for purposes of the plea?
yes, Your Honor, in all her cases.
All right, ma'am, to the charges in this case, in all of your cases, ma'am, to the charges of resisting an officer without violence, a municipal ordinance violation, and another municipal ordinance violation, ma'am, which is an alcoholic beverage violation. Ma'am, how do you plead? Guilty, not guilty, or no contest?
No contest and not guilty.
Okay, those are two different things. So if you say not guilty, you're saying, I didn't do this, I want to go to trial. If you're telling me that you're pleading no contest, what you're saying is, I just don't want to fight, I want to just go ahead and take the plea. So which one is it?
May I ask what would be the plea?
Remember,
Ma'am,
I just
ma'am.
told you that it would be an adjudication, court costs, and time served.
I'll
either-
plead no contest.
Okay, are you sure?
I'm not sure because
Okay,
I don't
she's
know
not sure
about these charges, ma'am. All my charges was thrown out last year when I went to court.
All right, ma'am,
All
I'm
right,
so
ma'am.
sorry. This morning, I will not be able to accept your plea because it's become, I'm
ma'am.
sorry.
I'm gonna plead not guilty.
Oh,
Yes,
well,
ma'am, that's your plea.
that, we'll take it. We'll accept your your not guilty plea, okay, ma'am? But the court does find probable cause otherwise to detain you, okay? The court is going to set the bond as to count one. I'm gonna leave it in the amount of $100. There is no.
I can't afford that. I can't afford it. So I plead no contest, ma'am. I'm sorry.
I'm sorry, ma'am, but I will not be accepting your plea this morning because it's clear to this court that you're not understanding.
I do understand. I understand, ma'am. I understand 100%.
Okay, but it's not to the court's satisfaction this morning, so no, I will not be accepting a plea offer from you this morning. Okay, the court's gonna leave the bond at $100. Count two, municipal ordinance, no charge. Count three is a $50 for a total of $150. Your next court date will be on December 16th, okay? Good luck to you, ma'am.
See you in court, ma'am.
Thank you. So my bond's $50.
$150.
I can't afford $150, ma'am.
I understand, ma'am. You're gonna do the best that you can, okay?
See you in
I
court, ma'am.
can't afford it.
You
All
said that,
right.
ma'am.
Sir, I can't afford that bond.
I understand, but ma'am, I am done with your case. I have to go on to the
Judge.
next case, okay? I'm so sorry, but
We'll
I
see you in
can't
court,
take your
ma'am.
plea this morning. All right? Okay.
Can I have Mr. Chang here at the main?
All right, Mr. Chang. Good morning, sir.
Right here, Senator. Right here.
All right. Good morning, Mr. Chang.
Good morning, ma'am.
All right, Mr. Chang. Sir, you are charged with one count of sexual battery on a victim of the 18 years or older by a person 18 years or older. Sir, the court, having reviewed the probable cause affidavit, I do find probable cause to detain you. State what says you as to bond.
Jones has information. I don't have any issue with him going first.
Please.
I did speak to his daughter Allison, who says he's the integral part of the family. He does take the grandkids, her 4-year-old and 8-year-old, to their doctor appointments, after-school programs, things of that nature. The family is only able to come up with $250, so a $2,500 bond.
Any priors? Has anyone had any contact with the alleged victim?
No, Your Honor, but I can advise the court, this is a filed case, so.
Okay, so this
myself
case
and
is
our
filed.
office did have contact with the alleged victim.
Yes, I do recall reading that in the probable cause affidavit. All right,
Your Honor?
please.
Okay, I do want to, I think the court should be aware, because it is referenced in the probable cause affidavit, that there was
Second case?
an ongoing investigation.
Yes, I did see that.
And law enforcement did present from what I can tell, a not in custody report for battery. I can advise the court the charge was ultimately declined. From what I can tell, that was done because Mr. Chang agreed to complete a sexual harassment course and give a $500 donation to women in distress.
Hey,
That being said, Your Honor, I do have concerns. I am going to request a $25,000 bond, no victim contact, no return to Ocean Drive Chiropractic and Wellness Center. I'm also going to be requesting an additional release condition that Mr. Chang may not work in any capacity as a massage therapist until further order of the court.
right, defense?
Judge, I can tell the court that he's lived here for approximately 3 years. He's not currently working. And when I spoke to him, he indicated that he's relying on his family for help in order to bond out. And as the bondsman indicated, they can only afford about $2,000, I think he said $2,000, $2,500, somewhere in that neighborhood. So based on that, Judge, we would be asking for the bond to be set at $2,000. And I understand all the other conditions in that, but as a matter of trying to get him out, he can't afford any more than that.
Okay, the court, sir, the court is going to be setting bond in this case in the amount of $25,000. You are to have no contact with the alleged victim in this case, sir. The court is also going to acquiesce to the state's request that you are to surrender, sir, your license, or excuse me, not surrender your license, but you are not to work at the Oceans, I'm sorry, what's the name of it?
The incident location was Ocean Drive Chiropractic and Wellness Center.
You are not to return to the Ocean Drive Chiropractic and Wellness Center, sir. You are also not to perform any services anywhere as a massage therapist. Furthermore, I think I've already said this, you are to have no contact with the alleged victim or any member of the victim's family. Do you understand that, sir?
Say it again.
Yes, ma'am.
Okay, anything else?
No, Your Honor.
All right, thank you very much, and good luck to you all.
Thank you, Your Honor.
Thank you. Okay, is there anyone who needs the services of the interpreter? And which interpreter is here? Spanish, good morning. Does anyone need the services of the Spanish interpreter? ¿Alguien más necesita un interpreter?
Judge, we do have a Spanish here.
Which,
On page seven,
go ahead.
Juan Hernandez.
Juan Hernandez. Okay, let me find it. Are you here for Juan Hernandez? Okay, come on up, please. I believe his family is here for him as well.
Do you have an attorney?
All right, good morning, Mr. Hernandez.
Buenos días, señor Hernández.
Buenos dias.
Buenos dias.
Good morning.
Okay, Mr. Hernandez, oh, I'm sorry, please, ma'am, raise your right hand. Do you swear or affirm that you will translate from English to Spanish, Spanish to English to the best of your ability? All right. Thank you. Please state your name for the record.
Alicia Stegmo.
Okay, good morning. So, Mr. Hernandez Guerrero, sir, you are charged with,
Guerrero.
You are-
Señor, se le acusa.
you are charged with 1 count of robbery by sudden
Cargo
snatching
de robo alando.
without a firearm or
Sin un
weapon.
arma de fuego o arma.
Count 2 is a touch or strike
Cargo
battery.
número 2 es una agresión, tocar o golpear.
It's a domestic violence count.
Es un cargo de violencia doméstica.
Count 3, sir, is tampering in
Y
a
es
misdemeanor proceeding.
manoseando en un delito menor, en proceso.
Sir, the court finds probable
el
cause to
juez
detain
haya
you.
por motivo justificado para detenerlo.
Mr. Phillip,
Okay, now there's some folks who are here from your
Hay personas que
family.
están aquí de su familia.
Okay, I'm gonna give them an opportunity to
Voy
say
a darle una
something.
oportunidad de decir algo.
Okay? Ma'am?
Señora.
Oh, if you can just come and talk in front of the microphone, I'm sorry.
We were unable to find a lawyer. We found out he was in processing at 1 a.m. and I couldn't get in contact with no one by 7:30 a.m. That's my dad.
Mi papá no podía contratar un
excuse me.
abogado a las 7:30, a las 1 de la mañana fue cuando lo procesaron.
My parents got into an argument about like,
Wait.
hold on.
No,
I-
wait. Do you remember when I said for him not to talk about the facts of the case?
Yeah.
You two do not talk about the facts of his case. I know that you might think that you might be helping, but it's not gonna be helpful for him for you to tell me about the facts of his case when the prosecutor is sitting right here and you don't yet have an attorney, okay? So,
My parents have resolved their issues. Everything was fine. There's no problem. We want to drop everything.
I
We
understand.
want him home. We want him contact. We want contact with him. We want him home. We don't want him there. I want to take him out. This morning is actually my graduation, so we were supposed to get ready to go to Tampa.
you're graduating from where?
Tampa.
From high school, college? I'm very sorry that you have to be here for this, number one. Okay, what is your name?
Jackie.
Jackie. I want you to take a deep breath, okay? Because I know that this is an emotional situation. Okay?
We want him home. We want to drop everything.
I understand. But I want you to understand my position as the judge is I don't get to make the decision if the case can be dropped or not. That only rests with the state attorney's office,
Okay.
okay? So as of right now, I'm only here to determine if there's any probable cause to detain him.
Okay.
And based on the allegations in this probable cause affidavit, there is enough for me to detain him.
Okay.
So now I have to determine how much of a bond I need to set for him,
Okay.
okay?
And I can take him out today.
If you're able to post the bond, absolutely, you can bond him out. What time is your graduation?
It's at 6 p.m. We're supposed to be on the road by 12.
Okay, all right. Number one, congratulations on your graduation,
Thank you.
okay? Because it's an important accomplishment,
Yes, it is.
all right? And I am very sorry that you have to go through this, all right? State, what says you as to bond?
Well, Your Honor, I heard what the witness said. I'm concerned because it doesn't seem to be consistent with what the alleged victim advised law enforcement when provided with the risk assessment questions. Your Honor, I know from my own experience that one of those questions has there been violence in the past?
Never.
And as the court is aware, the alleged
Y el
victim
juez está enterado que la alegada víctima
answered yes to all the risk assessment
contestó
questions.
sí a todas las preguntas de asesoramiento para riesgo.
There has never been violence in the past. That wasn't a question that was asked.
Does he have,
habido violencia en el pasado? Eso no es una pregunta que ha preguntado.
does he have any any priors?
¿Él tiene antecedentes?
I see no history, Your
No veo
Honor.
historial, su señoría.
Okay,
I
so,
also do know that,
También sé
according to this report,
que según este informe,
now I don't know if it was this witness
no sé si
or
fue
if there's
ese
another
testigo
daughter,
o otra hija,
but that one of the daughters
is also the alleged victim in the case as well. I'm aware.
alegadamente la víctima en el caso también. Estoy enterada.
No, I was going to state specifically, felt the need to pull Mr. Hernandez Guerrero
Off of the alleged victim, yes, the court is aware.
Tuvo que alar al señor Hernández Herrero de la víctima.
That stated, what are you asking for in terms of bond?
¿Qué pide su fianza?
I'd be asking for 1,500
Estoy
on 1 and
pidiendo
3,
por 1.500
Okay.
en 1 y 3,
2,500 on 2,
2.500 en el 2
and no victim contact.
y no contacto con la víctima.
So 1,500 on 1 and 3,
1.500 en 1 y 3,
and, I'm sorry, you said 2,500 on 2,
2.500 en el 2,
for a total of $5,500.
total total de $5,500.
Yes, ma'am.
Do you understand how the bond system works?
No, I can't
Okay.
afford more than $1,000.
The good news for you is that there is a bondsman who is just here in this courtroom, so you can probably go and talk to him and find out what percentage you have to put down in terms of bond. But I would imagine that if I set the bond at this much, you'd be able to afford that, okay? So what the court is going to do, I am going to go ahead and go along with the state's request. As to count 1 and count 3, the court is going to set bond in the amount of $1,500.
Poner 1,500 en la primera y tercera.
As to count 2, I'm going to set bond in the amount of $2,500.
$1,500.
I understand, ma'am, the circumstances, but I am going to have to order a no harmful contact in this case.
No contacto de
I
daño
have
en
to,
este
ma'am.
caso.
Why?
Why is because my concern is about the facts of what's alleged in this probable cause affidavit, okay? So yes, I will be ordering a no harmful contact in this case.
Your Honor,
Yes?
the state would object to a no harmful.
Excuse, you wanted a full no contact?
Quieren un completo no contacto.
There is really, first, it is very difficult to enforce a no harmful
Es muy
contact order.
difícil
Please.
hacer cumplir.
Hold on one second, and is the alleged victim here?
La víctima alegada está aquí.
And Your Honor, I can tell you, it's my understanding from communications today
De la comunicación,
that the alleged victim is okay with the no contact.
que la alegada víctima
All right, the
está
court is going to enter a no contact order.
No contacto. Vamos a entrar a una
Okay.
orden de no contacto.
Ma'am, we can't change that, please, back to no. Everything's resolved.
No, I understand, but today is not the day for us to have this conversation. Remember, today is only a very limited hearing. I'm literally here only to determine probable cause and to set a bond, okay? My interest is in protecting the community and the safety of your family as well, all right? So that stated, I am going to order no contact,
Así que voy a
okay?
ordenar no contacto.
So there is to be no contact at all. I'm so sorry, but it's going to have to be that way,
Disculpa, pero
all
tiene
right?
que ser así.
And the court is setting bond as stated. All right, good luck to you.
Buena suerte a ustedes.
Is there anyone else who needs the services of the
¿Alguien más
Spanish
necesita
interpreter?
un intérprete en español?
Not in Maine.
Anywhere else? Paul
¿En
Ryan?
otro lado?
Not that I've been advised, Your Honor.
Conti, North Broward? Anybody need the services of the Spanish interpreter?
No, we're good, Your Honor.
All right, thank you very much, ma'am. You have a great day. Bye-bye. Okay, I'm so sorry, folks. I am going to go ahead and start calling the rest of these people because I understand I have some other people in the audience. Let me try to call these. Okay, no, I think I'm going to go ahead and call these because these look like the, is he back from the city or is he still outside? He left? Okay, well, all right, so then I'll put the rest of his cases over here. All right,
Mr. Akwar's case, the state
please.
Mr. Gottlieb is Mr. Akwar's attorney. He's on his way.
He's on his way? All right,
Yes.
so then I'll wait. I'll put that off to the side then. All right, let me just run through this very quickly then. How about Ms. Favors?
Paul Ryan, Your Honor.
Good morning, ma'am. How are you?
Good morning.
How do you say your first name?
Zaquisha.
Okay, because I did not want to mess it up. Ms. Aquisha Favors, good morning. All right, ma'am, you are charged with 1 count of trespassing in an unoccupied structure or conveyance, ma'am. The court does find probable cause to detain you. Is there any reason she can't resolve this case?
What do you,
Hold
What do
on,
you mean by
hold on, Ms.
Oh, wait.
Favors.
The only concern I would have, Your Honor, is it's a trespass that involves someone's private property, namely a vehicle. I don't even have a victim's name. or
Got it.
phone
All
number.
right, so she can't resolve the case. They have not yet had contact with the alleged victim. All right, in terms of bond, what says you state?
Your Honor, I'm fine with an ROR.
Okay, all right, ma'am, I don't know if you heard him, but the state is okay with the court releasing you on your own recognizance, okay? That's an ROR, so I'm gonna go ahead and ROR you. Ma'am, you're not to, go back, hold on. This car was allegedly,
what's it called?
well, it's a vehicle. All right, you're not to return back to the Arrigo Dodge in Tamarack, okay?
Released on your own recognizance, Ms. Favors. When you're winning, it's best to remain silent.
What he's saying is, I'm letting you go, okay? You're no bond, I'm not gonna do anything, you get to go, but you cannot go back to that Arrigo Dodge. You understand?
Yes, but I never been there before.
All right, well, let's keep it that way. All right? Thank you, ma'am. Okay, Kelly Chapman.
Yes, ma'am.
Good morning, Ms. Chapman. How are you?
Doing well. How are you?
I'm doing just fine. Ms. Chapman, it looks like ma'am, you were picked up on a number of capiases, 2 felonies and 3 misdemeanors, ma'am. You also have a status hearing on December 16th at 8:30 on your felony, and on your misdemeanor, it looks like you also have a status on December 17th at 8:30. As to the 2 felony capiases, those are both no bonds. As to the other 3, those bonds, the misdemeanors, count 3, the bond was $250. Count 4 and 5, the bonds were $500 each. But since you're being held no bond, ma'am, you're not going to be able to leave anyway. But the court does find probable cause otherwise to detain you. All right, good luck to you.
Thank you.
Kathy Geddes. Bonded?
Yes, Judge.
All right, court would have otherwise found probable cause, but she bonded. Quintera Neal.
Good morning, Your Honor. Paul Ryan.
All right, good morning.
Good morning, Your Honor. I invited Miss Neal to join us this morning, and she said no.
Okay, she refused. Defense? Would you like me to reset this?
Yes, please, Judge.
All right, we will go ahead and reset this. Okay, William Darrell Lee. Good morning, Mr. Lee. How are you, sir?
Shocked, Your Honor.
Shocked. Why are you shocked?
Well, I came back on a plane last night and I was picked up at the airport, and I was confronted why.
Well, I can
And
tell you
I've got-
why. So it looks like, Mr. Lee, that you were picked up on an out-of-state hold for a felony. It's a parole violation, sir.
I know, I've been off parole for almost 5 years, over 5 years.
Okay, well, it looks like that's what it was, and it says something about a DUI, so you might have had a DUI capias?
That was what my my sentence was 5 years. And,
So I'm suspecting that it has something to do with that case, but that is why you're being held, sir. And they are finding it to be, hold on a second.
And from 2013, I
From
got off in
Texas?
2014. Yes, ma'am.
Yeah, I'm reading it. It's from Texas. All right, but there's nothing I can do about that. It's a no bond hold, sir, okay? I do find probable cause, so you'll have to wait until they can resolve that with you. All right, good luck to you, sir. Samuel Richard. Mr. Plant, I'm about to call all the rest of your cases. Mr. Richard, good morning, sir.
Morning.
All right, Mr. Richard, sir, looks like you have also been picked up on an out-of-state hold, sir, for a felony. It's an ad charge. It looks like it's out of Colorado, for forgery. Sir, the court does find probable cause otherwise to detain you, and it's no bond, okay? So you'll have to wait until you can resolve that. Good luck to you, sir. All right, Mr. Plant, we are going to be calling, hold on.
North Broward.
Plumber. Actually, Mr. Plant, do you represent the city of Fort Lauderdale?
Yes, Your Honor.
Okay, Michael Pittman.
Maine. Michael Pittman.
He's on his way up.
Thank you, Mr. Farbarek.
Good morning, Mr. Pittman.
Good morning.
Mr. Pittman, do you recognize me?
Oh, yeah.
Yes.
Yes.
Yes, Mr. Pittman. You notice I'm not happy with you this morning, Mr. Pittman. We just had this conversation.
Yes, ma'am.
So, Mr. Plant, the reason I know Mr. Pittman is because he is a participant in the community court.
Yes, Your Honor. Of course.
Mr. Pittman, what's one of the rules of community court? No new arrests, no drinking. So, would you like to come back to community court?
Yeah.
Yeah?
Yes.
I'm not gonna tell you that I'm happy. I'm quite disappointed to see you here, Mr. Pittman.
Yes, ma'am.
All right, so that's stated. Mr.
Judge will agree
Weissman
to-
has already agreed, yes, Brad Weissman, yes, from the city of Fort Lauderdale, as Ms. Carr, Davika Carr. They both have agreed to allow him back into the
yes.
community court, so I'm gonna take you back. I'd like to see you next week, Wednesday. Do you understand? You're gonna be in community court Wednesday, December 18th at 9 a.m.
Yes, ma'am.
Mr. Pittman, you have a lot of thinking to do while you're in there.
Yes, ma'am.
All right, I'll see you on Wednesday.
Okay.
Mr. Pittman, you cannot return to wherever that location was, okay?
Okay.
Court finds probable cause.
Thank
The
you,
court is going to, gonna ROR him.
Make sure you go, Mr. Pittman.
Okay, let's see, sorry about that, hold on.
Come on down this way, Fish.
McCollum. Randall McCollum. I think this is one of yours, yes, this is.
Yes,
one
no,
of yours.
yes, also Maine. Also Fort Lauderdale could do community court.
Mr. McCollum, good morning, sir.
Good morning, ma'am.
All right, Mr. McCollum, sir, you have been picked up on a misdemeanor capias, sir. Your next court date is December 16th at 9 a.m.
Can I resolve this today?
You have a couple of options. Have you ever heard of the community court?
Yes, ma'am.
Do you want to try community court, or do you want to resolve this?
I want to resolve this today.
Okay. And what is your, I'm sorry?
I have a job opportunity to go to work, and I don't want to miss this opportunity.
Okay,
I'm
and
on social- I'm on disability, man.
where are you going to be working?
It's Steve's Lawn Service.
All right, raise your right hand. Do you swear or affirm that the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth to help you?
Yes, ma'am, I do.
Okay, please state your full name, sir.
Put your hand down.
Randall Carmine.
You can put your hand down. You can put your hand down. Okay, Mr. McCollum, so you just told this court that you have a job offer, is that correct?
Yes, ma'am, and I have a pretty good chance.
Okay, well, there's a difference. Do you have a chance or you have an actual offer? Is I have the chance to win the lottery, but that's not happening until I have the money in my hand.
Would you
You
like
see
to
what I
he-
mean?
Sorry, would you like to hear about community court?
Do you know what community court is?
That's the federal courthouse, isn't it?
Nope. No. Let me tell you about community court.
Exactly.
Community court is an and I want everybody else in the jail to please listen. Because if you are eligible for community court, you might be able to participate. What community court is, it is a program for individuals who may be facing homelessness, just like yourself, sir, or who may be having some sort of other issues in terms of needing some help from the court. In terms of alcohol issues, it looks like that's what happened in your case here, sir. So if
Yes,
you'd
ma'am.
like to do that, you can come to the community court. You'll be able to go to get detoxed. You'll be able to go from detox to IRT. From IRT, you'll be able to go to different types of job training, etc. You do have to do a hang on, there is a catch, because you do have to do 10 hours of community service in the city of Fort Lauderdale. If you are able to do all of those things, I will dismiss the charges against you, so you don't have to do
Yes.
time served.
Yes, ma'am, understood.
So, do you want to do it?
Yes, ma'am.
Okay, but here's the deal about community court as well. You have to actually show up.
Okay.
Because if you do miss community court, you'll be right back where you started.
Okay, and where is this courthouse?
It's actually not done in the courthouse. It's done at Fort Lauderdale City Hall, just over the bridge. Do you know where it is?
Yes, ma'am, I do.
All right.
100 Andrews Avenue.
Exactly. So if I sign an order today, I'm going to order you to come to community court on Wednesday. That is next week, Wednesday, December 18th. You need to be there at 9 a.m.
Yes, ma'am.
All right, sir. We're going to go ahead and I'll transfer your case over to community court. And by the way, I am the presiding judge, so I will remember you.
You have to go. Please go, sir,
Okay?
Wednesday.
So in that case, sir, the court is going to ROR you on this case in terms of the misdemeanor, and I'm going to transfer your case over to the community court if I can have an order prepared to that effect. Okay, please understand that if you fail to appear, that the court will issue a warrant for your arrest.
I'll be there.
All right, thank you, sir, and welcome to the village. That's what we call it in community court. You can talk to Mr. Pittman.
Yes, ma'am. Thank you very
We
much.
just sat down.
All right, thank you, sir. Hold on, I think I have Mr. Sanders. Folks in the audience, I'm going to get to your cases. I apologize. I don't want to have you just sitting there. Oh, Mr. Sims, I think is one.
Yes, Your Honor, May.
And Johnson is the next one. Okay.
Douglas Sims.
All right, Douglas Sims.
I'm hoping he heard everything we just discussed. Same page 10.
All right, good morning, Mr. Sims. How are you, sir?
I'm okay, ma'am.
All right, Mr. Sims, sir, looks like you too were picked up on a misdemeanor capias, sir. It's a municipal ordinance violation for possession of drug paraphernalia. Sir, did you just hear me talk about community court?
Yeah, I was kind of not there, but I was dozing off back then.
It's a
All
helping
right.
court. We have the judge here.
All right, so let's try this again. So what community court is, sir, it's an opportunity for you to try to get some help to clean up your act. Sir, if you have a drug problem or an alcohol problem, you can go over to community court, but you're shaking your head no, so maybe that might not be an option for you.
No, I don't think so.
All righty then. That stated, your next court date is December 16th, sir, at 8:30. The court finds probable cause to otherwise detain you. Any reason he can't resolve?
No, Your Honor, no reason.
All right, sir, does he have priors?
Douglas Sims.
I've-
It
years
could affect his
ago, I
license,
haven't
but
been into-
you understand with community court, you would be RRR.
yes, I would like to be all right.
You cut off the judge and didn't let her finish.
All right, sir, if you want to resolve this case, the court can offer you a time served. Do you wish to resolve the case?
Yes, ma'am.
All right, raise your right hand, please. Do you swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth to help you?
Yes, ma'am.
All right, please put your hand down. Sir, can you tell me your full name?
Douglas Leon Sims Jr.
All right, sir, how far did you go in school?
I graduated at the age of 36.
From high school?
Yes, Broward County Boot Camp.
You can just answer the question.
No, well, that's a good thing. I'm impressed. Good job for graduating from high school. Sir, have you ever been treated for a mental illness?
Yes.
Are you currently under a doctor's care?
Yes, Henderson Clinic, ma'am.
Okay, well, is there anything, are you taking any medication or anything that's going to prevent you from understanding what's going on this morning?
No.
Okay, are you currently under the influence of alcohol, narcotics, or any other medications?
No, ma'am, at all. No.
All right, sir, the terms of the plea that the court was offering you was an adjudication, court costs, and time served. Do you wish to resolve your case?
Yes, ma'am.
All right, do you understand the terms of the plea?
Yes.
Did you have an opportunity to discuss the terms of the plea with your lawyer? That's this gentleman that's here in the courtroom talking to you.
Yes, ma'am.
Has anyone promised you anything other than the terms that the court just told you about?
No.
Is anyone forcing you or threatening you in any way to accept the plea?
No.
Do you understand that there will not be a trial if you accept this plea?
Yes, ma'am.
Do you understand that if you accept this plea, you'll be giving up certain constitutional rights?
Yes, ma'am.
Did you hear me go over that long list of rights with the other young lady who was about to take a plea?
No.
All right, I'm going to try it again. So everybody else, please listen because I don't want to keep repeating myself. That's why you're laughing. All right.
Oh, no, I was asleep. I was back there asleep. I apologize.
That's okay. We're going to wake you up
right.
now. All right? So that stated, here are the constitutional rights if you accept this plea that you will be giving up. You're giving up the right to plead not guilty and to have a trial by jury, the right to an attorney or to have the court appoint one for you if you cannot afford one, the right to remain silent and not incriminate yourself, the right to have the state prove you guilty beyond a reasonable doubt, the right to confront witnesses against you and to cross-examine those witnesses, the right to defend yourself by calling witnesses and presenting evidence, and the right to appeal the conviction and sentence to a higher court. Do you understand those constitutional rights as I have explained them to you?
Yes, ma'am.
Okay, understanding those rights, do you wish to proceed to trial with those rights, or do you wish to waive those rights and accept the plea offer?
I wish to waive those rights and accept the plea offer, ma'am.
All right, do you understand that if you're not a United States citizen, that this plea will subject you to be deported?
Yes, ma'am.
All right, do you understand that entering in this plea may cause your driving privileges to be suspended, revoked, or you will be ineligible to get a driver's license?
Yes, ma'am.
Okay, have you had enough time to discuss the case, any possible defenses, and the plea with your attorney?
Yes.
Okay, is there anything else you want your attorney to do to defend your case that he hasn't already done for you?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
All right, state defense, are we stipulating for the purposes of this plea that there is a
Yes, sir.
factual basis?
Yes, Your Honor, I'll stipulate. on both
All
sides.
right, sir, to the charges of violation of a municipal ordinance, sir, which is possession of the drug paraphernalia, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, sir. The court will accept your no contest plea. I find that the defendant has freely, voluntarily, and intelligently waived his rights. I also find that the defendant has knowingly entered into the plea and understands the nature of the charges and the consequences of the plea. I find the defendant competent, coherent, and alert. And I find after a review of the arrest affidavit and/or the charging document and the stipulation of the parties that there is a factual basis for the plea, sir, and I will sentence you accordingly. The court will adjudicate you, sir, sentence you to time served, and order you to pay court costs. You will have 60 days from today to go ahead and pay those court costs. Good luck to you, sir.
Thank
Good
you,
luck,
ma'am.
sir.
And if you change your mind about community court, you can still come visit
Wednesday morning.
every Wednesday. All right, I believe I have Mr. Olden Osteen Johnson.
Judge, he bonded?
He bonded. All right, the court would otherwise have found probable cause, but he did bond. And I think that's all your cases, is that right?
There's one more municipal ordinance on page 11.
Okay, hold on, what's the name?
Herbie Crussell. Herbie Crussell.
Crussell.
He's been reset. I don't know if he's there now. It
Is
was-
Herbie Crussell here?
It was right after Olden Johnson.
All right, I see you. Good morning, Mr. Crussell. How are you, sir?
How you doing, ma'am?
I'm doing just fine. Mr. Crussell, sir, you were charged with one count of the violation of a municipal ordinance violation for panhandling.
Yes, I am.
Okay, sir, there is no community court for this one. Sir, do you wish to resolve your case?
I would, but I would like to be in the community court. I can't be in that.
That
Well,
would be great. You could visit.
you can always visit me. It's every Wednesday. It's open to the public. You do not have to have a charge to come and visit me. If you want the services, you can still come. But the problem is that right now it's only in the city of Fort Lauderdale. And this
Okay.
was not in Fort Lauderdale. This one was in Pompano, so I can't take you there. But I'm working on it. But that
Okay.
stated, do you want to resolve your case?
I would if I could go. I'd like to go home today. I live with my mother now.
You can
My
resolve,
mother
sir.
moved down to, my mother moved down to Deerfield, and the only reason I wasn't staying with her is because she went to visit her sick sister in Lakeland.
Remember, nope. Mr. Crussell, do you remember when I said I was gonna cut you off if you start talking about the facts of your case? Don't talk about it, okay? But you want to resolve this?
Yeah, I haven't seen you in some time though.
Okay, raise your,
We don't want to see it.
are you sure you want to resolve this?
I hope so.
Okay, I don't know.
Why? What does it look like? What's
it's
the
a-
offer?
The offer is an adjudication, court costs, and time served.
Yes, ma'am.
You want to do it?
Yes, ma'am.
You sure?
Yes,
Are
ma'am.
you really sure?
I'm positive.
All right, raise your right hand. Do you swear or affirm that the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth to help you?
Yes, I do.
All right, please state your full name, sir.
Herbie Crusoe,
Mr. Crucell, how far did you go in school?
1 year college,
Okay, sir, what were you studying?
criminal justice.
Oh, okay. All right, have you ever been treated for a mental illness?
No, ma'am.
Okay, are you under the influence of alcohol, narcotics, or any other medication?
No, ma'am.
Is there anything preventing you from understanding what's going on this morning?
No, ma'am.
All right, sir, you understand that the terms of the plea here is going to be an adjudication, court cost, time served. You're not to return back to the location of your arrest, which is in the middle of the road in Pompano. You understand? I think this is on Atlantic. You can't go back there.
Yes, ma'am.
All right, that's stated, sir. Do you understand the terms of the plea?
Yes, ma'am.
Has anyone promised you anything other than the terms of the plea that the court just told you about?
No, ma'am.
Is anyone forcing you or threatening you in any way to accept the plea?
No, ma'am.
Do you understand that there will not be a trial if you accept this plea?
No, ma'am. Yes, ma'am. Yes, ma'am.
Do you understand that if you accept this plea, you'll be giving up certain constitutional rights?
Yes, ma'am.
Did you hear me go over that long list of rights?
Yes, ma'am.
Okay, did you understand all those rights?
Yes, ma'am.
Do you understand those rights and that, understanding those rights, do you wish to proceed to trial with those rights, or do you want to waive them and accept the plea offer?
Waive them and accept the plea offer.
Okay, do you understand that if you're not a United States citizen, that this plea will subject you to deportation?
Yes, Yes, ma'am.
Do you understand that entering the, no, that doesn't apply. Have you had enough time to discuss the case, any possible defenses in the plea with your attorney?
Yes, ma'am.
All right, is there anything else you want your attorney to do to defend your case that he hasn't already done for you?
No, ma'am.
Are you satisfied with your attorney's representation? You
Yes,
should
ma'am.
be. All right, sir, to the
Thank you,
charge,
Judge.
sir, of panhandling, how do you plead? Guilty, not guilty, or no contest?
No contest.
State defense, are we stipulating for the purposes of this plea that there is a factual basis?
Yes, Your Honor.
All right, sir, that stated, the court will accept your plea, sir, and I find that the defendant has freely, voluntarily, and intelligently waived his rights. I also find that the defendant has knowingly entered into the plea and understands the nature and the consequences of the plea. I find the defendant to be competent, coherent, and alert, and I find after a review of the affidavit under the charging document and the stipulation of the parties that there is a factual basis for the purpose of the plea. The court will sentence you accordingly to an adjudication, court costs, and time served. Sir, you have 60 days to pay those court costs. You are not to return back to the location of your arrest, which is at Atlantic Boulevard. Okay? Good luck to you, sir. But you can still come to community court anytime you'd like to.
Okay.
All right. I think now, Mr. Plant, that's all of your cases.
It's Robert Williams.
Just kidding. Robert Williams.
This is really the last one. He also has state cases, so that's good, Mr. Faberic's there.
Okay. let me
Robert
get-
Theron Williams, page 14. He has the two VOPs,
Hold on.
one new state case, one new.
Oh, found it? Okay.
Thank you, Judge.
All right. Mr. Williams, sir, good morning.
Good morning, how you doing?
I'm doing all right. Mr. Williams, sir, it looks like, sir, you were picked up on 2 felony violation of probation warrants, sir. Those are no bond holds. And you were also picked up on 2 misdemeanor capiases. Those have bonds of $250 each. The court does find probable cause. Your next court date is December 16th at 8:30, okay? Good luck to you, sir.
Can I resolve it? Can I resolve it?
No, sir, you cannot resolve it. They're felonies. I cannot do that at magistrates.
Judge, we would agree to PC on the new cases as well.
All right, the court does find probable cause there, too. Thank you, sir.
Thank you. That's
Now,
it.
I think that's the end of your cases.
That's it.
All right, thank you. You have a great one. First, come on down. Mr. Hawes, come on down. Mr. Hawes, what do you have? I guess, what do you have? Good morning.
Actually, there's 2 clients who I was going to appear on behalf of. Randall Haas, here on behalf of James Villaroyale.
That's the third one on the docket. Mr. James Villaroyale, please. James Glenn Villaroyale. What's the second case?
The second one is Peter Sarsor.
Okay, hang on one
This is
second.
Mr. Villaroyale.
Good morning, Mr. Villaroyale. How are you, sir?
Good morning, good.
All right, sir, your attorney, Mr. Hawes, is here in open court, sir. Sir, I wanted to let you know, sir, that you were charged with 1 count of aggravated battery causing bodily harm. Sir, count 2 is an aggravated assault with a deadly weapon, domestic violence. Sir, the court does find probable cause to detain you. State what says you has to bond.
Your Honor, I'm gonna make the same request I made for the, for Ms. Sarsour this morning, a $2,500 bond on each count. No victim contact.
I'm sorry, you said, I cannot hear you. You said 2,500 on each count.
Yes.
Okay,
No victim contact. He had a DUI 2015.
okay.
He was arrested for domestic violence battery in 2010 against a different alleged victim. That was dropped.
All right, Mr. Hawes.
Your Honor, I think that both of these crimes arise from the very same incident, and I think the allegations are the same in both. So I would ask that if the court is going to set a bond only as to one and ROR him on the other. And I would ask for a $2,500 bond total. I've known Mr. Villaroyale for a very long time. He's got very solid roots in the community, Your Honor. He owns his home. And as a matter of fact, the reason that I brought up Ms. Sarsor's name is because she's the alleged victim in his case. and
Yes,
he's the
did I
alleged
call that
victim.
already? I think I did.
Yes, you did. You did, and my intention was to get here on time to represent both of them, but unfortunately, I just missed. I think a bondsman had the case called earlier.
Yes,
But
and what
they're
did I
each
do with
other's
her
victims.
bond? Hold on, what did I do with her bond?
1,500 each.
I did 1,500 each? All right, so then the court's going to do the same in this case. The court's going to set bond as to count 1 and count 2, $1,500 each. You're to have no contact with the alleged victim in the case.
Now, here's the situation, Your Honor, and hopefully you can assist me with this. My client owns the home where these incidents occurred.
Okay?
They share a child in common, And at the time of the incidents, Ms. Sarsar was residing with my client in his home. He owned the home long before she moved in, but she moved in because of the birth of their child. So, he doesn't have any problem at all with her having contact with him. I don't know if the court's prepared to do so, but
The
doesn't
concern that I
want to do
have
that.
is that there's a child who,
I'm not sure what request is being made.
the request is to essentially not have the no contact.
Your Honor, we've got allegations of two individuals going at each other with scissors, both claiming that they're attacking one another. I think there needs to be no contact at this
Well, I'm
point in
just
time.
talking about with respect to Ms. Sarsar. You entered a no contact order with respect to Ms. Sarsar. He doesn't have any interest in that no contact order. He's willing to have contact with her. So that's with respect to Ms. Sarsar. Now, I guess with respect to Mr. Villarreal, we'd have to ask Ms. Sarsar what her position is on that. The problem is that, as I said, they share the same home. It's his home. He
Well-
wanted them both, the child and the mother, to live there because he wanted to be with his child.
Unfortunately, someone's going to have to move.
Not gonna be him.
No.
So if he
It's his
wants the
home.
mother, if he wants the mother of his child to be out on the street,
No,
that's
she
up
won't
to
be on the
him.
street. Her
Fo-
parents are
Folks,
local.
folks,
Her
folks.
parents are local.
All right, I'm leaving the bonds as to count 1 and count 2 at $1,500. There is still no contact. Just gonna leave it as no contact and surrender any weapons, because, deadly weapon. There's a deadly weapon, so he has to surrender any and all weapons.
I think the deadly weapon was a pair of scissors that were in the house and a tea. So I don't know if there's any deadly weapon. So I'm just-
Yeah, we're just gonna surrender any weapons that he may have, all right? We're gonna surrender any weapons,
See, it's
just to be on the
different.
safe side, all right? We're gonna surrender weapons.
So, if she gets out first, she's gonna go to their home.
It's a standard.
And I have to somehow navigate my way around that.
I mean, I can sign an order that allows her to go to the home for purposes of removing her personal items.
be great.
Obviously, I have no objection to doing that. He can't be there when that's happening, though.
And
Okay.
what I would request, and I believe it's on the statutory no contact order, that she can go accompanied by law.
Yes, with the escort, yes, so ordered. All right, give me an order and I'll go ahead and sign those for you.
And, so he's not gonna remove his personal items?
No, she is.
She is, okay, great.
Yes,
I'll do
if
that.
what you're telling me is correct, that it's his home and she's not on the deed, it's his house.
And I guess the public defender's office representing Ms. Sarsar, so I guess I'll show the order to them after I drive.
All right, thank you, thank you. All right, great to see you. Anybody else? First row? Sir? Please tell me, what case? Jeremy Atkins? Okay, let me find it. Jeremy Atkins? Okay, let me find that case.
It's on the way, ma'am.
All right, I found it. Okay, I found it.
My name is Joe Clark, Judge. I represent Mr. Atkins pro bono.
Good morning, Mr. Clark. Good to see you, sir.
I'm sorry, Your Honor, it's Clark, K-L-O-C-K.
Clark, I'm so sorry. I thought you said Clark.
Most people do.
Mr. Clark, good morning,
There are
sir.
very few Clarks and a lot more Clarks.
Great to see you, Mr. Clark.
And Judge, Mr. Atkins is indigent. Judge, there's a
We
13-page
need to get him
document.
up.
I know, hang on one second. He's not here yet. He has to be brought, you can't see him yet. Oh, here he is.
There he is.
All right, good morning, Mr. Atkins. How are you, sir?
Colorful. Okay.
I don't know if he
Your
can
Honor,
hear, wait, can you hear me? Oh, there we go. Good morning, Mr. Atkins. How are you?
Good morning, okay?
All right, Mr. Atkins, sir, I want to let you know that you're here today for a probable cause determination. Mr. Clark is your attorney, and he is here in open court with me, okay? Sir, you were charged with 1 count of premeditated murder. The court has reviewed the probable cause affidavit in this case, sir. The court does find probable cause to detain you.
Excuse me, Your Honor.
Yes.
There's not probable cause in this arrest affidavit.
Okay, hold on one second.
Do I get to argue?
Yes, I was
Okay.
going, just give me 1 second to get there. State.
Well, first of all, Your Honor, before Mr. Clark makes any argument, pursuant to the rules of procedure, there is probable cause. That determination isn't actually even necessary, because, one moment, I just want to get the judge right. Judge Orlando found probable cause when he signed the arrest warrant.
I know.
But
A
that
prior
being-
judge has already made that determination.
But that being said, I would go even a step further, and the state is going to be seeking a no bond hold pursuant to Esazavi State. Your Honor, I do believe, based on the affidavit prepared by Detective Coronado of the Sunrise Police Department, that the proof of guilt is evident, the presumption of guilt is great, that Mr. Atkins committed this first-degree premeditated murder.
If counsel's suggesting this be an Arthur hearing, is that what
No.
he's suggesting?
That's not what, I'm not
That's not what
suggesting.
he's suggesting.
Okay, fine. Okay, Judge, let's just take a look at the arrest affidavit, okay?
Oh, wait, counsel, another judge has already made a probable cause
So
determination
then
in
what's
this
the purpose of
case.
this hearing?
Well, you weren't here yesterday, and we reset the hearing for
Well,
today.
I wasn't here yesterday, Judge, because I had eye surgery the day before.
I know, but this is the note that I have. The case was reset for today because counsel wasn't present,
Okay,
that's
then
why.
why was the hearing set for yesterday, Your Honor?
Sir, I was not the judge on that case yesterday, sir. Your client is charged with premeditated murder. Judge Orlando, in signing the warrant, found him, already found probable cause, sir. So
But
he
there
is going
is-
to be held without bond until further order of the court. The
But
order,
Your Honor
of
has
course,
the ability to review that under the rules.
and I did review it, and I did find probable cause, so now I'd like to hear your argument.
Okay,
regarding
my
probable
argument,
cause.
Judge, is that there is nothing in this affidavit that indicates that this man shot that person.
Okay.
Okay, the only thing that there is evidence of here is that a male wearing a gray hoodie went into the house. The young lady who, along with her father, is accused of first-degree murder, has implicated this young man, except that there's nothing in the affidavit that says that he told her that he shot this individual. The only thing that's in the affidavit is he says that he took money from him. So we know that she drove up to the house. We know that she dropped somebody off, that somebody went in the house. We don't know that the person who went in the house shot him. These guys know what they're writing. There was no spelling errors in the entire thing. There were no grammar errors in the entire thing. The affidavit says that they had a search warrant that indicated they could get cell phone records that showed a number of things, including the length of a cell phone call. They indicate in the arrest affidavit with respect to the boyfriend, the amount of time that was spent on the cell phone. There's an indication that there's one call to this gentleman down in South Dade. It does not indicate how long the cell phone call was, so it could just as well have been a missed call. So the fact of the matter is, Judge, there's nothing to show that this guy killed that guy. There's nothing to show that there's any premeditation. And I have the greatest respect for Judge Orlando, but he just is wrong about this. There is no probable cause on the face of this affidavit.
Okay. Response?
Your Honor, there is additional evidence that counsel failed to mention, that being video surveillance evidence showing an individual from the co-arrestee's car entering the home, coming back to the car, getting, I believe the allegations are getting then latex gloves, then going back into the house. It corroborates the statement given by the co-arrestee, Your Honor, who also is the one that advised law enforcement that Mr. Atkins is the one, in fact, that was in her vehicle that went into the car at that time. The video surveillance does not show any other vehicles going to the residence, any other individuals going into that residence. So there's nobody else that could have gone into that home and killed the victim.
Well, perhaps, Judge, I wasn't very articulate in my comments. We don't know when the guy was shot. Counsel doesn't know when the guy was shot. In the arrest affidavit, the officer simply says that he killed him. He doesn't know either. All we know is that this lady, this 16-year-old girl, and we have several pages talking about her relationship with DT, whoever he is, supposedly went down to Homestead, picked this guy up, brought him back up there. There's nothing to indicate why it was premeditated. There's nothing to indicate that he did it. And Judge, look, don't you think that the affidavit would say in it, I whacked that guy when he got back in the car, or I took care of it, or there's some statement for him? No, Judge. We have two people implicated in a murder who've decided that this guy is going to be the GOAT, okay? And that's all we have. There's nothing in this affidavit, and as I said, I have the greatest respect for Judge Orlando. He kicked it. There's no probable cause on the face of this affidavit. And respectfully, Your Honor, if this goes up to the 4th District, I think they're going to find on a writ of habeas corpus that there's no probable cause. These guys know how to write an arrest affidavit. There's nothing in here to indicate that this man did it.
Your Honor, I would also note that the witness, she implicated herself, that she knew it was discussed between the three of them. That he was, excuse me, sir, I didn't interrupt you. He was involved in those conversations with the two other co-arrestees, that she was aware of those conversations, that the plan itself was to kill the victim. That's why when the other co-arrestee contacted her on the phone shortly thereafter, he inquired Was he killed? She claims, she advises she knew because her understanding was that there was only going to be one shot fired, Your Honor.
Judge,
Why?
I'm sorry.
Excuse
Why
me,
do,
sir. Sir, excuse me. Your Honor, she can be found credible because she's implicating herself in this murder. She's not, and I'm glad I'm amusing counsel.
You are-
I don't
you
really
are
find this
Okay,
amusing.
gentlemen, I'm sorry, but I don't find it appropriate to be laughing in court. That is not appropriate behavior.
okay, Your Honor, if I may, counsel has not indicated one thing to indicate that this man killed him. I think it's wonderful that somebody got in the car. I think it's wonderful that they came out and got some latex gloves. Unless he's being charged with stealing latex gloves, there's no other crime alleged. They know how to write an arrest affidavit, Judge. Have you ever seen a murder arrest affidavit where there's not a statement made by somebody, I killed him? Where is the statement in there that he killed him?
If counsel.
Where, excuse me, I'm not
Excuse
allowed to
me,
interrupt him.
gentlemen. Excuse me.
There's nothing in this affidavit to indicate that this man killed that person. There's nowhere in this affidavit to indicate that no one else was in the house. There's nothing in this affidavit that indicates when this man was killed. These guys in Broward County are pros. That's not what I'm used to in my county, Judge. These guys are pros. They know how to write an arrest affidavit, and if they had any of those allegations, they would have put them in there. There's nothing in there to hold this man.
Any further argument?
No, ma'am.
And briefly, I would just state, if counsel's arguing that every murder case requires an admission by the defendant.
It does
I'm
not. This court is
confident that-
aware that that does not occur.
And Your Honor, what we have here is circumstantial evidence, which the court is also aware of, when the jury, if this charge is filed, and the jury is ultimately instructed, is to be given just as much weight as direct evidence, Your Honor.
All right, gentlemen. Again, I have actually reviewed the probable cause affidavit in this case, including all of the documents that were attached thereto. After hearing arguments from counsel this morning, the court is convinced that there is probable cause to detain this gentleman, and he will be held no bond. Again, this is without prejudice for the defendant to set a motion to set bond with the assigned division judge with respect to any type of hearing under State v. Arthur. But as of today, the court is finding probable cause, and I also find the proof of guilt to be evident or the presumption to be great.
So, Judge, you are using the Arthur standard, correct?
I beg your pardon,
Are you
counsel?
using the Arthur standard or not,
I
Your
have
Honor?
announced my standard,
Very good.
counsel.
Your Honor, I
Okay,
would just
if
announce
I
that-
may, Your Honor, I wasn't finished talking.
I was
Would you
doing for your
please
benefit,
declare
sir.
this individual to be indigent and order the transcript to be prepared so I can take an appeal? to the
Has he
fourth district?
filled out an application for
I don't know,
indigency?
Your Honor, because number one, I wasn't able to get any papers showing what the charges were against him. There's no case number in the court file that you can find.
Okay.
So what I'd like the court to do is determine that so a transcript can be
Well,
prepared
I
and I
can't
can
make
take an
that
appeal.
hang on. I can't make that determination without the proper paperwork to actually be filled out. That's actually a determination that's actually made by the clerk and then ratified by the court. So he does need to fill out an indigency application. Madam Clerk, do we have one? Or do they have one in the jail? Does anyone know? Do they have one in the jail?
Judge, we do, but the girl, you can give me 1 second, I can try to catch her. She just did leave.
Got it, please.
Give me 1
Thank you.
second.
We will make sure that we get an application over to him so that it can be done appropriately,
And then, Your Honor, once that's done, can the transcript be prepared so I can take an appeal?
by all means.
Thank you.
Your Honor, and I just want to, for record purposes, concede, and I believe it was the court's intent, that any findings you made today are applicable to the first appearance only.
Yeah, that's all I said.
No,
That's-
I know, and I just want to make a record of that. Clearly, in the state concedes, the defense is entitled to seek an evidentiary Arthur hearing in front of the assigned judge.
Which is what I just said.
Yeah, I know, I'm just,
Okay.
the state concedes that as well.
Okay.
And that the state would have to satisfy proof evident or presumption.
Presumption.
I don't
Yes.
mean to be
Again, at that
disrespectful. Everything that you did today is on this piece of paper. So if I take an appeal, it's the piece of paper. There's nothing with respect to respectfully that Your Honor said that would be considered by the appellate court as being indicative of anything except what this piece of paper said. I think we all know that.
I don't know what piece of paper you're holding
I'm
up.
referring to the arrest affidavit
Okay,
and the arrest order signed by Judge Orlando.
okay,
That was what you were referring to as well, Judge, I assume.
okay. Apparently I have not made myself clear. I'll try this again. Judge Orlando already found probable cause. You asked me to review the same probable cause. I reviewed the same probable cause affidavit. My own independent review of that affidavit I do find that there is sufficient probable cause to detain him. He's being held no bond. Today, I am not holding an Arthur hearing. That is not appropriate to do at the first appearance hearing. That is something that can be done in front of the division judge. With respect to the first appearance purposes, that's all I'm doing today, is only for probable cause determination and regarding issues as to bond.
I'm
That's
sorry,
it.
Judge. All I'm trying to do is determine.
No, I understand. I
that we're
do.
talking about the same piece of paper, so that that's the record when I go up. That's all, Judge.
I understand, and the record is obviously whatever the record here says.
Thank
All
you,
right,
Judge.
thank you very much. Okay. Now, anybody else? Good morning,
Good morning, Your Honor.
Miss Small Williams. How are you doing?
I am doing well. Valerie Small Williams on behalf of Larry Covington.
All right, hold on, I gotta find you.
Go right after Mr. Atkins.
Okay, somewhere in the middle.
Judge, I was able to catch her, and she's having him fill out an affidavit now.
Awesome, thank you so very much. I appreciate your
No
help.
problem.
All right. Oh, I'm sorry, I gotta find him because I don't have a docket like you guys have.
It'll be way at the
It's
back.
like almost the last case,
found it.
Judge.
Larry Jamar Covington? I'm guessing this is an ad charge. Yes, it is.
Thank you.
All right, good morning, Mr. Covington. How are you, sir?
I'm all right, and yourself?
I'm
How
doing
Miss Valerie?
just fine. I was just gonna tell you, your attorney, she's here. All right, sir, it looks like this is an ad charge. This is charge number 20. Sir, you were charged with burglary of an unoccupied structure, unarmed, I think during a state of emergency. Is that what this says?
Your Honor, I don't, it's just charged as a burglary.
It's just charged as a burglary conveyance. Okay.
I didn't understand the line about the state of emergency either, Your Honor.
Yeah, I didn't get, okay.
I will stipulate that there's probable cause in this count.
And Your Honor, what I would request, unless Ms. Small Williams has an objection, we just had an ad charge with Mr. Covington the other day on a burglary conveyance. We agreed on a $2,500 bond.
I don't have a problem with a $2,500 bond.
So
on this
ordered.
count.
All right, the court will set bond in the amount of $2,500 as to this count, okay? Good luck to you, sir. All right,
Mr.
always a
Covington.
pleasure to see you, ma'am.
All right, Your Honor.
All right, I think I just saw Mr. Gottlieb walk in. Good morning, Mr. Gottlieb. I'm doing just fine. Mr. Gottlieb, we have Emmanuel Okwar.
Yes, ma'am. How are you?
I'm doing just fine.
Good.
Oh, hold on, he's coming up. Mr. Okwar? I think I'm in the right place. All right. Good morning, Mr. Okwar. Your attorney is here. Mr. Gottlieb is here, okay?
Good morning, ma'am.
All right, sir. It looks like you were charged with one count of domestic violence. What? Oh, well, okay. You're charged with one count of violating a domestic violence injunction, one count of intimidation, writing or sending a threat to kill or injure, and two violations of felony, violations of probation. Am I reading this? These are pretrial warrants. It just says something else. Okay, so you got two pretrial violations. All right. State?
Your Honor, it's okay. Your Honor, I'm going to be requesting a bond in the following amounts. I'm going to be requesting a $25,000 bond on count one, a $150,000 bond on count two. I understand that he has no bond holds on 3 and 4, but I am going to be asking for pretrial release with a GPS monitor level 1 on counts 1 and 2, no victim contact, in order that Mr. Okwar not be in possession of any firearms or weapons or ammunition until further order of the court. Your Honor, I'm making this request because frankly, I don't know what's going to happen in the future on counts 3 and 4, so I'm just addressing this under the belief that at some point, if he becomes eligible for release, I believe these bonds and conditions would be appropriate. Your Honor, the warrant does go over a brief history of the case. I am concerned because my understanding was on the case he was on pretrial, at first that there was a level 1 GPS, which then got modified to a level 2.
Okay.
And apparently there's still been allegations of conduct. There have been threats of violence against these protected parties, Your Honor. I am also, I can tell you that I spoke with a representative for Mr. Dance, who is one of the alleged victims, and he is very concerned for his safety as well. I do believe, Your Honor, that Mr. Okwar has financial means. The original bonds on counts 3 and 4 were $100,000 each. He posted those bonds and was released on a GPS monitor. he has just shown an unwillingness to follow the conditions set forward by both his judge at first appearance and by Judge Merrigan at a later date.
Yes, sir, Mr. Gottlieb.
Judge, I was just retained on the case. Candidly, I received a phone call yesterday about the new charges. I didn't know anything about them, so I've not filed a notice of appearance on them. There's a long history, and I've reviewed some documents. I don't think it's appropriate for magistrate court at this point in time to go over all that. I'll address his bonds with the whoever the judge is, because I understand that Judge Merrigan signed an order of recusal, I believe
think I saw that,
yesterday.
okay.
So I'll stipulate to probable cause at this point in time and just address it with whomever is going to be presiding over the case.
All right, so then, okay, so Mr. Okor, what the court is going to do, as to count one, the court is going to set bond in the amount of $25,000. Count two in the amount of $150,000. Count three and count four, those are no bond holds. However, the court is going to put you on pretrial level 1. The court is further going to order you to have no contact with any of the alleged victims in this case. You are also to surrender any and all weapons, including all firearms. Do you understand, sir? I didn't hear an answer. Mr. Okor, do you understand, sir?
I think his mic is likely off.
Oh, is it off? You can't, that's why you can't, gotcha.
Hello?
Okay, gotcha.
I can't afford the bond.
Okay, I know that you can't afford the bond, but I don't know if you heard everything else I said because the mic might have been off, but let me try that again, okay? So count one is 25,000, count two is 150, count three and four was no bond, but I'm not gonna have those as no bond. Those are gonna be put, you're gonna be put on pretrial, a level 1 pretrial, okay? You're to have no weapons, surrender any and all firearms, to have no contact with the alleged victim, okay? Do you understand?
Yes, ma'am.
Okay, now, I do understand that you can't afford the bond, but as of right now, it is what it is. That's the bond that I'm going to be setting, okay? You're gonna have your next court date. I don't know when that is. Does anybody?
I'm not sure, Your Honor, if it's okay with the court, just so there can be no confusion and it's clear, if the court has no objection, we just state the names of the victims.
Please.
Thank you, Your Honor. And I believe this would include,
Mr. Herb,
Alan Dans, Circuit Court Judge Edward Merrigan.
Okay, so do you hear, Mr. Okor, and I really want to make sure you understand this very, very clearly. You are to have zero contact with the following people. Judge Ed Merrigan, do not call him, do not text him, do not email. No contact literally means no contact. Not you, not somebody else on your behalf. Do you understand? The same is true for the prosecutor assigned in this case, okay? You are to have zero contact with them.
That would be Assistant State Attorney Gabriella Jaden.
And that would be Assistant State Attorney Gabriella Jaden. You are to have zero contact with the Assistant State Attorney. Do you understand, sir?
Yes, ma'am.
And also Alan Dans, Your Honor.
And Alan Dans, that is the other alleged victim in this case. Those three people, you cannot have any contact with them. Do you understand?
Yes, ma'am.
All right, thank you very much, sir, okay? Good luck to you.
And I just want to make sure I didn't mishear. Your Honor is keeping 3 and 4 at no bond?
I thought you wanted me to put those on pretrial level 1.
No, those were 1 and 2. 3 and
Oh.
4 can't, I don't believe 3 and 4 can be
I'm
modified.
sorry,
or
but let me
ordered
fix
by
that.
the judge.
Strike that. Count 3 and 4, those are no bond. Count 1 and 2 will be pretrial level 1. Is that what you want?
Please, yes, Your Honor.
In addition to the bonds?
Yes. in
So
advance of
ordered.
bond.
Yes. Yes, I did. The charge on the finding is the violation of injunction for protection against domestic violence. I'm sorry, I gotta write that down for you, but yes, that is the. All right, so ordered.
Thank you so much.
Thank you very much for coming in, Mr. Gottlieb.
Happy holidays. Sure.
Happy holidays.
Excuse me. I think that's unfair.
Okay, I know, Mr. Okor, but do you remember when I said, don't talk about the facts of your case? Because there's a prosecutor here taking notes on everything that you say?
Mr. Okor,
All right, so don't say anything about your case.
Mr. Okor, I'm going to come out and see you and discuss this with you. Thank Thank you,
All right,
Judge.
your lawyer, thank you.
Just another day.
Okay, is there anybody else in the audience that I need to call? No? Okay, all right, so let me go back to docket order, I'm so sorry. All right. Mr. Farberic, you're doing great, you're doing great. Okay, Victor Huipio. Victor Huipio,
Medical reset.
medical reset?
No, I'm saying.
No, just kidding, not this case, okay, different case.
He was asking me about it, I said it was.
Judge, I think, I don't know where you are in the docket. I think we left off on page 8 with a Brian Florescu.
Mike, he's at the end of the docket, he was a medical reset.
Oh, okay, thank you.
Okay, so that, okay, well, I don't know how that happened, but all right, but I have, hold on, I have a Robert Franklin McClure. I don't know. Are these all out of order? All right, are you Mr. McClure?
Yes, ma'am.
Good morning, sir. How are you today?
Could be better.
All right, let's see if we can't make today a little bit better for you, all right, sir? Yes, Mr. McClure, sir, it looks like you are charged with 1 count of touch or strike battery domestic violence, sir. You're also charged with 1 count of child abuse without great bodily harm. The court does find probable cause to detain you, sir. Okay, you are to have no contact with the alleged victims in this case. Do you understand?
Yes.
Okay, now, state, what says you as to bond?
Your Honor, I'd be requesting a $1,500 bond on count 1 and 2, no victim contact.
I'm sorry, you said 1,500 on count 1 and what?
And 2.
And 2. All right, defense?
Judge, do you know what page we're on? I'm sorry.
Page 6.
I got it. Okay, thank you. Judge, I can tell the court that he's lived here all of his life, that he's single, that he has 4 children that are aged 11 to 19. He also works detailing cars. He does have family members that are here as well. He can only afford about right in the neighborhood of $100 to $150 in bond. I would ask the court if the court would consider setting bond at $1,000 on each case.
State? All right, so ordered. As to count 1, it'll be $1,000. Count 2, $1,000. Okay, remember what I said. You're to have no contact with the alleged victims in this case, okay?
Okay.
All right, good luck to you, sir. Court finds probable cause. Okay, now I'm not sure which order we ended up in, but Brian Michael Florescu. Brian Michael Florescu? I don't
Judge,
know.
I'm showing on the docket that he's on medical loan. I don't know if that's still,
Medical still?
he's
Okay.
still out, yes.
All right, medical reset.
This is with domestics.
Okay. Christoph or Christopher Figueroa Sanchez?
Judge, when I spoke to him, he indicated he wanted to try to work this out if possible.
Okay. Yes. Okay, I'm familiar. All right, sir. Mr. Figueroa Sanchez, good morning, sir.
Good morning, Judge.
All right, sir, it looks like this one is a misdemeanor capias, sir. You got picked up for, this was a trespass. Do you understand?
Yes, ma'am.
All right, the court finds probable cause. This is an ad charge, but my understanding was that you were going to be released to the James Club?
Yes, ma'am.
Who's picking you up from James Club? Is that Mr. Ray?
Yes, ma'am.
Okay,
They were
does,
supposed to pick me up yesterday, but then this showed up.
okay, so does Mr. Ray know that you're here right now?
Yeah, he's aware. Should be aware.
Okay. All right, so state, any reason he can't resolve this?
Oh, no, Your Honor, if he would like to resolve it, I would definitely make an offer.
What's the offer?
The offer would be,
And understanding what James Club recovery is, the court is very familiar, so if he's going to James Club, there's,
I'm familiar as well, Your Honor.
so,
James Love. It's a withhold court cost no return to the 7-Eleven at 4800 South State Road 7 in Hollywood.
all right, you want to take it?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth to help you?
I do, ma'am.
All right, you can put your hand down. Can you tell me your full name, please?
Christopher Figueroa Sanchez,
Okay, how far did you go in school?
graduated high school.
And how old are you?
33.
Have you ever been treated for a mental illness?
No, ma'am.
Are you currently under the influence of any alcohol, narcotics, or any medication?
No, ma'am.
Anything preventing you from understanding what's going on today?
No, ma'am.
Okay. State, the terms of the plea here are a withhold of adjudication and court costs, correct?
Yes, ma'am.
And no return to the location of your arrest. Understanding that, sir, do you understand the terms of the plea?
Yes, ma'am.
Did you have an opportunity to discuss the terms of the plea with your lawyer?
Yes, ma'am.
Has anyone promised you anything other than the terms that the court just told you about?
No, ma'am.
Is anyone forcing you or threatening you in any way to accept this plea?
No, ma'am.
Do you understand that there will not be a trial if you accept this plea?
Yes, ma'am.
That if you accept this plea, you'll be giving up certain constitutional rights?
Yes, ma'am.
Did you hear me go over that long list of rights?
Yes, ma'am.
Do you understand every one of those rights?
Yes, ma'am.
Do you understand that, understanding those rights, do you wish to proceed to trial with those rights, or do you wish to waive them and accept the plea offer?
I'll waive them and accept the plea offer, ma'am.
Okay, do you understand that if you're not a United States citizen, that this plea will subject you to deportation?
Yes, ma'am.
Do you understand? Nope, that doesn't apply. Have you had enough time to discuss this case, any possible defenses in the plea with your attorney?
Yes.
Is there anything that you want your attorney to do to defend your case that they haven't already done for you?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Right. You really should be. All right, state defense, are we stipulating that the facts as set forth in the arrest affidavit, if proven at trial, will be sufficient to to support a prima facie case?
Yes, Judge.
All right, sir, to the charges of trespassing, sir, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, sir, the court will accept your no contest plea, and I find that a defendant has freely, voluntarily, and intelligently waived his rights. I find that the defendant has knowingly entered into the plea and understands the nature of the charges and the consequences of the plea. I find the defendant to be competent, coherent, and alert, and I find after a review of the arresting affidavit and/or charging document, and based upon the stipulation of the parties, I think I asked that, is there a stipulation for a factual basis for the plea? Is that a yes? Oh, okay, yes. All right, the court will sentence you accordingly, sir. Will be a withhold of adjudication and court costs. You're not to return back to that 7-Eleven location. And if I can ask you one favor, when you're there at the James Club, give it your all. Give it baby steps, because every day is going to be a struggle, but you can do it.
I will, ma'am.
All right?
Thank you.
All right, good luck to you, sir.
You too. Have a good day.
Daryl Weaver? Okay. Oh, I found him. Okay.
Say, Judge, I'm sorry, who did you call?
Okay, Daryl Weaver?
Yes. Yes.
Okay. All right. So what was being said was that, so Mr. Weaver, good morning, sir.
How you doing today, man?
I'm doing just fine. How are you?
I'm doing great.
All right, sir. So it looks on count 1, sir, you were charged with a burglary of an occupied dwelling. Count 2 was a burglary with assault or battery. Count 3 was a felony battery domestic violence. Count 4 was a felony capias. Count 5 states court order misdemeanor, but that is actually going to be changed. I'm sorry, you want me to change that language to say writ?
Hold on.
Okay, so count 5 is actually a writ, sir. So that stated, those counts, sir, those are all no bond holds with respect to counts 1, 2, 3, and 4. So there's to be no bond to be set in those cases. Those are no bonds.
Your Honor,
Yes?
he is legally entitled to bonds on counts 1 and 3.
On 1 and 3?
The state would be seeking a no bond hold on count 2, the burglary with the battery.
Okay.
It's a punishable by life offense. Would be seeking finding a proof evident or presumption great for first appearance purposes only, relying upon the probable cause affidavit. Your Honor, I would ask that the court not exercise, if you make that finding, that he be held no bond. Both of these new cases before Your Honor involve the same alleged victim and Mr. Weaver unlawfully entering her
The home. Yes, I'm aware. I read the PC affidavit here. So counts 1 and count 3, sir, you are eligible for bond, but count 2, you are not. So count 2 and count 4 actually are not eligible for bond. Those are both no bonds.
Yeah, 2 and 4.
Yeah, 2 and 4 are no bond.
Well, 2 depends on what finding you make, obviously. But 4, yes, that was set by Judge Porter.
Yes, all right. So that stated, sir, all right, so Mr. Weaver, sir, you are charged with the offense, sir, of the burglary with assault or battery. That is a first-degree felony, sir, punishable by life in prison. That stated, sir, the court, like I said, I've reviewed the probable cause affidavit in your case. I do find probable cause. I also find proof of guilt to be evident or the presumption great, sir. Therefore, you are going to be held without bond until further order of the court as to that count, in addition to the other counts, with the exception of count 1. Again, this order is without prejudice for the defendant to file a motion to set a bond with the assigned division judge and to request a hearing under State v. Arthur. As to count 1, State.
Your Honor, State would be requesting a $15,000 bond on 1 and a $5,000 bond on 3. Obviously, no victim contact, Judge.
Okay, sir. As to count 1, the court is going to set bond in the amount of $15,000. As to count 3, the court will set bond in the amount of $5,000. You're to have zero contact with the alleged victim in this case. Understand what that means. Do not text, do not email, don't have anybody else do it either, okay? You're to have zero contact. And like I said, count 2, sir, is no bond, and count 4 is no bond.
In light of the fact that there's a no bond hold on count 4, we would defer any argument regarding proof evident presumption great
For the
until
division
such time
judge.
as Mr. Weaver can appear before his division judge.
So ordered. All right, thank you, sir. I was going to tell you, the next hearing date is December 16th at 8:30. But what was the bond, you were asking me, the bond on?
The bond on count 3.
Count 3 is $5,000.
Thank you, Judge.
Thank you, sir. Good luck to you. Again, no contact with the victim. Okay. I think these might have belonged at the bottom. Okay. Garvin Anthony Foster. All right, Mr. Foster, good morning, sir. All right, Mr. Foster, sir, you are charged with 1 count of trespassing on an occupied structure or conveyance, sir. The court does find probable cause to detain you. Hold on 1 second, there's a correction to be made.
The charge is still trespassing, however, it's trespassing on occupied structure, which changes the bond from 5.
Okay, I don't know if you heard that, but they are correcting your information, sir. You are now charged with trespassing in an unoccupied structure or conveyance, which lowers the bond, sir. The original bond was $100, now it's down to $25. Okay, State, any reason he can't resolve this?
No, Your Honor.
Offer?
The adjudication time served.
Sir, do you wish to resolve your case? Oh, wait, he can't, I hit the mic?
Got it.
Thanks.
Yes, Your
Okay, so did you hear everything I said?
Yes, Your Honor.
All right, so do you want to resolve this case?
Yes, Your Honor.
Okay, the state has offered you an adjudication, court costs, and time served. Do you understand?
Thank you, Your Honor.
All right, then raise your right hand, please. Sir, do you swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth to help you?
Yes, Your Honor.
Okay, can you please tell me your full name and your age?
My name is Garvin Anthony Foster. My full age is 21378.
Okay,
My age is
how old are you?
41 years old.
All right, sir. Okay, how far did you go in school?
High school.
Have you ever been treated for a mental illness?
No, Your Honor.
Are you currently under the influence of alcohol, narcotics, or any other medication? Anything preventing you from understanding what's going on today?
No, Your Honor.
All right, sir. The state has articulated the terms of the plea to be an adjudication and court cost, sir, and time served. You're also not to return back to the location of your arrest. Do you understand?
Yes, Your Honor.
Okay. I have to ask. Did you have an opportunity to discuss the terms of the plea with your lawyer? That's the guy right next to you. Okay. Has anyone promised you anything other than the terms that the court just told you?
No, Your Honor.
Is anyone forcing you or threatening you in any way to accept this plea?
No, Your Honor.
Do you understand that there will not be a trial if you accept this plea?
No, Your Honor.
And that if you accept this plea, that you'll be giving up certain constitutional rights?
Yes, Your Honor.
Did you hear me go over that long list of constitutional rights?
Yes, Your Honor.
Okay, did you understand all of those rights?
Yes, Your Honor.
Now, understanding those rights, do you wish to proceed to a trial with those rights, or do you wish to waive them and accept this plea offer?
Yes, Your Honor.
Nope, that's not what the question was. Do you want to waive those rights and accept the plea?
I just don't want to waive them. No,
Okay,
Your Honor.
so then I can't accept your plea. You don't want to waive those rights. You're not waiving them forever. You're waiving them for purposes of this case, for this plea.
Yes, Your Honor.
Judge, if I can have one
I was
second,
just
I'll-
going to suggest
Yeah.
that. I think I called everybody else. Yes, I did. Yep, I did. I'm making sure I called everybody I was supposed to. Okay, all called.
Judge, I believe that he wants to waive his rights.
All right then. Okay, so I'm gonna ask you again. Remember that long list of rights that we just talked about?
Yes, Your Honor.
Okay, now, do you understand those constitutional rights as they have been explained to you by your lawyer?
Yes, Your Honor.
Okay. Understanding those rights, do you wish to proceed to trial with those rights, or do you want to waive them and accept the plea offer?
Yes, Your Honor.
Okay, let's try that again. Are you saying yes, you want to waive them and accept the plea offer?
Yes, Your Honor.
Okay. Okay. Do you understand that if you are not a United States citizen, that this plea would subject you to deportation?
Yes, Your Honor.
Okay, do you understand that entering, nope, that doesn't apply to you. Have you had enough time to discuss this case, any possible defenses, and the plea with your attorney?
No, Your Honor.
Okay, do you want some more time to discuss it with your attorney, the man standing right next to you?
Yes, Your Honor.
Yeah?
Yeah.
Okay. Hang on, there's a
Take your
second.
time.
Sorry, hold on, wait. It's an executive session. Separate to Cindy immediately.
Judge, he's indicated to me that he's somewhere that he was supposed to be. So based on that, I don't feel comfortable pleading him out.
I was just going to suggest perhaps we delay this. All right then, no worries, okay? So what we'll do is the court is gonna find the probable cause. We're gonna go ahead and correct the information so that it makes sure that it states it's a trespass on an unoccupied structure or conveyance. The court is gonna leave the bond in the amount of $25, okay? I do find probable cause. Good luck to you, sir, okay? We will not be accepting any plea offers this morning.
All right.
Okay, Jarrell Jaquan Neal. All right, good morning, Mr. Neal. How are you, sir?
I'm good this morning.
All right, Mr. Neal. Sir, you are charged with one count of giving a false ID to a law enforcement officer. You're also charged with one count of trespassing in an unoccupied structure or conveyance. Sir, the court does find probable cause to detain you. State, what says you has to bond?
Nothing to add, Your Honor.
All right, sir.
Judge,
Oh, I'm sorry?
he did, He did want to try to work this out if possible.
Can we resolve this?
Yes.
Okay,
Oh, wait, no, I'm sorry. Yeah, this is a vacant home.
you can't?
Yeah, I mean, the issue is frankly, I just admittedly have not had an opportunity to speak with the homeowner.
Have not had a chance to speak to the victim yet, I'm sorry. So we can't,
And Your Honor, I can tell you, I'm showing that he's had cases within the past few years dismissed on competency grounds. He's had cases that went through Judge Port's division, Judge Lerner Wren's division.
okay, so,
I would recommend transferring.
I was just thinking that,
The
so,
issue is, just so the court's aware, Judge Lerner Wren is off the bench until the end of the year.
oh,
Hey, wait, hold up.
no, wait, don't say it, wait. Nope, no. Remember, I told you I was gonna cut you off if you talk about your case, please, don't talk about the facts of your case.
Because obviously, I'd be concerned that he wouldn't get to see
I know, you won't be
Judge
able to
Lerner Wren
see,
right away, so I wanted the court to be aware of that.
where is this out of? This is Lauderdale Lake, so no, this is not community court eligible.
No, Your Honor, this is,
No, wait, where is this?
Fort Lauderdale.
This is Fort Lauderdale, actually? Any history of violence? Any history of violent priors?
Okay. See, I can tell you, Your Honor, there were previous arrests that were dismissed that are classified by the Florida legislature as dangerous crimes, but they're not inherently violent, specifically burglaries of dwellings. I don't know if those are disqualifying. What's that?
Well,
Judge, I would ask, in light of the fact that these are misdemeanor cases, and in light of the fact that Judge Lerner Wren is not in until the end of the year, I would just ask the court to consider RORing him at this point. I don't know if we can set a court date for him, or if that has to be done through Judge Lerner Wren's office. But if we could transfer it, have him ROR'd on the case, that way he's out, he can show back up to Judge Lerner Wren.
state?
In light of the circumstances, Your Honor, I'm not gonna ask that he be held for 3 weeks before we can see Judge Lerner.
All right, so why don't we do that, okay? So then, Mr. Neal, what I'm gonna do is I'm going to RR you as to these case, this case today. Okay, I do otherwise find probable cause to detain you, but I will RR you. We're gonna transfer this case over to Judge Lerner Wren's division. I'll ask for the next available court date to be set for you, and I am gonna ask that you immediately show up to court. But in the interim, don't go back to wherever it was that you were arrested, okay?
Thank you.
Your Honor.
All right.
And I would just, if you could just advise Sir,
Wait, come on back, Mr. Neal. Hold on, not done yet.
that he should check in with either the public defender's office or the clerk's office to get his court date.
Okay, did you hear that, Mr. Neal? They just want you to make sure you check in with your lawyer, the public defender's office, or the clerk's office, so you can find out when your next court date is. Because it's really important that you show up to court, all right?
All right.
All right, sir, good luck to you. Okay, just need a transfer order to send that over to Judge Lerner Wren. Thank you. Okay, George Ford.
Main judge on his way up.
Okay. All right, good morning, Mr. Ford. How are you, sir?
Good morning, ma'am.
All right, Mr. Ford, sir, you were charged with 1 count of trespassing in an unoccupied structure or conveyance, sir. The court does find probable cause to detain you.
This involves the same home, Your Honor.
I was just gonna say, I think this is the exact same home.
Yes, it is.
All right. This is the same situation, so I don't have contact with the alleged victim as of right now, so I can't resolve this case.
He also,
He did want to try to resolve it, so I would just ask if the court would ROR him.
and Your Honor, he does not have, from what I can tell, as far as Broward, I don't see any violence in his,
All right, so would you have any objection to me RRing him?
no.
All right, sir. The court is gonna release you on your own recognizance, sir, okay? I do find probable cause otherwise to detain you. While you are out on bond, sir, please do not go back to the location of your arrest, okay? You are trespass warned from there. You cannot go back. Do you understand? But I need you to also check in with your public defender. That's that gentleman right there, Mr. Farbarek. I want to make sure you check in with him so you know when your next court date is, so you can show back to court, all right?
All right.
All right, sir. Happy holidays and good luck to you. Tommy Neely. All right, Mr. Neely, good morning, sir. How are you?
I'm blessed. Good morning. How are
All
you?
right, I'm doing just fine, sir. Mr. Neely, sir, it looks like you were picked up on a misdemeanor capias, sir, for a possession of drug paraphernalia. State any reason he can't resolve this?
No, ma'am.
All right, sir, what's the offer?
The offer would be Judge, excuse me, time served. He does have history.
All right, Mr. Neely, the state is offering you an adjudication, court costs, and time served, sir. Would you like to take that plea offer?
Yes, ma'am.
All right, please raise your right hand. Sir, do you swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth to help you?
Yes, ma'am.
Okay, you can put your hand down. Can you tell me your full name and your age, please?
Tommy Neely, 60,
All right, sir, how far did you go in school?
11th grade.
Have you ever been treated for a mental illness?
No, ma'am.
Are you currently under the influence of alcohol, narcotics, or any other medication?
No, ma'am.
Okay, the state is giving you an offer of an adjudication and court costs, sir, and time served. Do you understand the terms of the plea?
Yes, ma'am.
Did you have an opportunity to discuss the terms of the plea with your lawyer, the gentleman standing right next to you?
Yes, ma'am.
Has anyone promised you anything other than the terms that the court just heard?
No, ma'am.
Is anyone forcing you or threatening you in any way to accept the plea?
No, ma'am.
Do you understand that there will not be a trial if you accept this plea?
Yes, ma'am.
And that if you accept this plea, you'll be giving up certain constitutional rights?
Yes, ma'am.
Did you hear me go over that long list of constitutional rights?
Yes, ma'am.
All right, do you understand those constitutional rights?
Yes, ma'am.
Do you understand that you'll be waiving those constitutional rights if you decide to take this plea offer?
Yes, ma'am.
So, understanding that, do you wish to proceed to trial with the rights, or do you want to waive them and accept the plea offer?
I will accept the plea offer.
All right, do you understand that if you're not a United States citizen, that this plea will subject you to deportation?
Yes, ma'am.
Have you had enough time to discuss the case, any possible defenses in the plea with your attorney?
Yes, ma'am.
Is there anything else that you want your attorney to do to defend you, to defend your case that he hasn't already done for you?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
All right, sir. State defense, do we stipulate that for the purposes of the plea that there is a factual basis?
State stipulates, Judge.
All right, sir, to the charges of possession of drug paraphernalia, sir. How do you plead? Guilty, not guilty, or no contest?
No contest.
All right, sir. Upon the acceptance of your plea, I find that the defendant has freely, voluntarily, and intelligently waived his rights. I find that the defendant has knowingly entered into the plea and understands the nature of the charges and the consequences of the plea. I find the defendant to be competent, coherent, and alert. I find after a review of the arresting affidavit and/or the charging document and the stipulation of the parties that there is a factual basis for the plea, and I will sentence you accordingly, sir. The court will adjudicate you, sir, sentence you, an adjudication, court costs, time served. We'll give you 60 days to pay the court costs. Good luck to you, sir.
Thank you.
Hey, William Frederick Lomanak.
Yes, ma'am.
Good morning, Mr. Lomanak. How are you, sir?
I'm not doing so well.
All right, we'll see if we can do something today, all right? Mr. Lomanak, sir, you were charged with one count of touch or strike battery, sir. The court does find probable cause to detain you, okay? The court is going to order that you are to have absolutely no contact with the alleged victim in this case. Do you understand?
Yes, yes, sir. Yes, ma'am.
Okay, all right, let's
No, I understand. I understand.
Nervous?
Listen, I can tell you. I walked.
No. Remember when I said, you heard me say I was going to cut you off? Don't talk about the facts of your case, okay? Just
Okay, yes.
do not talk about the facts of your case. But that stated, I do find probable cause to detain you, okay? I want you to have no contact with the alleged victim. State what says you has to bond.
Your Honor, I'm going to ask at this point in time that the bond be kept in place, that the court order no victim contact.
All right,
First,
sir.
I don't believe Mr. Lomanak has sufficient ties in the community. I'm showing an at-large address in Orlando on the PC affidavit. Also, I do have concerns about Mr. Lomanak's mental health. I'm showing out of Leon County between 2009 and 2013. 10 separate mental health cases in civil court.
Okay, so should this case be transferred to Judge Lerner Wren?
Let me just.
I would think so.
I would think so.
I just had to make sure that there was no relationship, because if a case could qualify as domestic,
Yeah, no,
she would take it. So I just wanted to make sure that there was.
this looks to be a stranger.
Yeah, I mean, I don't have a problem with it being sent there, and if it doesn't.
If it doesn't meet the
Judge Loretta doesn't
qualifications,
think
she'll
it's
transfer it
appropriate.
back.
Exactly.
All right then, so Mr. Lomanak, the court is gonna set bond in the amount of $1,000, okay, sir? You're to have no contact with the alleged victim, okay? Furthermore, let's see, this case is gonna be transferred over to Judge Lerner Wren, okay? I don't know when your next court date is gonna be, but in the event that you are able to bond out, do not go back to where you were arrested, do not have any contact with the victim, okay?
Miss, I already tried calling the bond people last night, man. I walked up, I ain't say nothing to the woman.
No, 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 no.
Yes,
Please,
yes,
please,
yes, I'm
no,
telling you, I'm
no,
telling you,
do
man.
not talk
Matter
about the
fact,
facts
I'm
of your
finna go.
case.
Matter of fact,
Okay, thank you.
For the court's edification, I will contact Judge Lerner Wren Shea.
Please.
If he remains in custody, at a minimum, they may be able to get the doctor they use out there.
To at least have someone go out and do an evaluation.
Yeah, I'm gonna flag his case as
I
well.
was just gonna say, please have someone do that evaluation. All right, so ordered. Okay. Devilnear Yarnell Tilgman.
Main jail, I believe, Your Honor.
All right, good morning, sir. How do you say your last name? Oh, wait, hold on. They have to hit the button. Hold on. How do you say the last?
Tillman, the GHC solid.
All right, Mr. Tillman, good morning, sir. How are you today?
All right, and you?
I'm doing all right. Mr. Tillman, sir, it looks like, are these ad charges?
These are.
No.
The attempted murder and the possession of firearm like a convicted felon are change of charges.
Okay, so they're change of charges?
Yeah, they're really technicalities. The fraudulent use of ID is an ad charge.
Okay.
Your Honor, I reviewed the original findings.
Uh-huh.
Judge Davis made a finding for proof evident
Presumption grade, I see that.
felony murder. It was just the wording in the statute in the subsection. It was just it's a technicality. So I'd ask the court to adopt Judge Davis's previous finding.
Okay.
Since he did find proof evident presumption grade for the offense that Mr. Tilgman stands before the court on this morning.
All right, so, Mr. Tillman, what they're saying is that originally the first judge already found probable cause on the attempted murder, attempted felony murder, specified felony, and then they changed the charge to now attempted felony murder first degree. So I am going to adopt the previous judge's ruling with respect to this case and find probable cause as to all counts. You are going to be held no bond as to the, I'm sorry?
I'm sorry, Your Honor. On the possession of a firearm offense,
Yes?
that's bond eligible, and what happened, he was charged separately with that at first. He appeared before Judge Shulman on a weekend, separately than the attempted felony murder.
Okay.
So what she ended up doing on that case was RORing in a pretrial level 1.
On count 3?
Yes.
Okay.
So what I'm gonna be asking the court to do is set a $10,000 bond on that count. Since he's gonna be held no bond on the attempted felony murder, he'll accumulate gain time on the possession of firearm by convicted felon.
So count 3, you're asking me to set it at $10,000. Count 4, we'll leave it at $1,000? Okay, so count 1 will be set at $10,000, count 4 will be left at $1,000, and count 1 is no bond anyway.
Yes, sir.
Okay, so that'll be a no bond hold. All right, so the court will find probable cause and adopt the previous rulings by the court. So ordered. This is an attempted murder. So you are to have no contact with the alleged victim. Do you understand?
Say it again. Yes, ma'am.
All right, thank you, sir. Good luck to you.
All right.
Okay, Michael Woods?
All right, Your Honor. All right, ma'am.
Okay. All right, good morning, Mr. Woods. How are you, sir?
How you doing?
I'm doing all right. Mr. Woods, it looks like these are some additional counts, sir. These are 3 additional felony capiases that you were picked up on, sir. All of them have a bond of $750, and your next court date is December 16th at 8:30. All right? The court does find probable cause to detain you as to those, and I will leave bond in the amount of $750 as to each additional count. That's counts 12, 13, and 14. All right? So your next court date is December 16th. That's Monday. Good luck to you, sir. All right, Travis Ivan Cook?
He was in Conte, Judge. I spoke with him before court, and then I was advised by the deputy up there that he went back to his cell.
Okay, so would you like me to reset?
Brian, just to let you know, I was gonna be requesting a $1,500 bond. I don't know if that's, cause he's got $3,000 total bond.
I know.
Other charges. I
I
don't know.
know. I'd ask you to reset him, Judge. I
right.
don't know why he went back to his cell, but
All right, so we'll reset. We'll put him on for tomorrow.
thank you, Judge.
Mr. Brandon Marshall?
North Broward.
North Broward, he also left.
All right, we will
I just have that effect on
But,
people.
Your Honor,
Yes,
I don't
sir.
know if Mr. Reed has an objection. This is a filed misdemeanor upgrade. Mr. Marshall has multiple no bond holds for violation of pretrial.
Yeah, you can leave the bond at $750.
I will leave it so ordered. But am I resetting? No reset, yes?
No.
Nope, no reset. All right, the court finds probable cause, leave bond in the amount of $750. Joshua Green? Joshua Green?
Medical reset.
All right, we'll reset that. James Clarence McLeod? All right, good morning, Mr. McLeod, sir. How are you?
Fine, ma'am.
All right, Mr. McLeod, sir, you were charged with 1 count of grand theft. Sir, the court does find probable cause to detain you. The bond in this one is being set at $1,000, sir. In the event that you are able to bond out, you were to have no contact with the alleged victim in this case.
Yes, ma'am.
That would be Christopher Overby. And where is this location?
Same, I'm trying to tell you. It was 6 foot, the same thing.
Okay, wait. Do not talk about the facts of your case. Remember, everything is being recorded, and I can hear you. Don't talk about the facts of your case. All right. All right, so can't tell where this is.
It's just a home in.
Is it just a home? Is that what this is? Okay. All right, well, then, just no contact with the alleged victim, okay?
Judge, just so the court knows, he was with, I guess, those other two trespassing where they couldn't contact the victim.
Is that what this is?
I think that may be, yeah.
No, this is a grand
No, this is a grand theft. This was a grand theft from a house of a cell phone, iPhone 10.
There.
No,
Yeah, he's saying
do not talk about the facts of your case and don't admit to another crime in front of me, okay? Let's not do that. So for this case, which is only a grand theft, I don't have a trespass case for him at all. So I'm going to
Right,
leave, I'm gonna leave that bond at 1,000.
What I would ask, he's asked me to ask the court, he can't afford the $1,000 bond. He does have family members that live here in South Florida. They may be able to help him. He's not 100% sure, though. He said that they're not working. They don't have any money. I would ask the court to consider an ROR in this case.
Priors?
Yes, Judge. 2016 dealing in stolen property, false ownership info, and a pawn item. And this is just out of Broward. 2010 possession of cocaine. Cocaine 07.
Okay, it's not gonna happen today. I'm gonna leave the bond in the amount of $1,000. Good luck to you, sir.
Thank you, Judge.
All right. Franklin Antonio Brown.
He's on his way up, Judge.
All right, no worries. Is this the same place? All right, Mr. Brown, good morning, sir. How are you?
Good morning, I'm good.
All right, Mr. Brown, sir, it looks like you are charged with 1 count of grand theft, okay? The court does find probable cause to detain you. All right, you are not to go back, wait, where is this? This one is, this is a grocery store. Okay. And it doesn't actually say the name of the store. It just says grocery and food store. All right, sir. Gold Coast Beverage. All right, sir. The court finds probable cause. If you're able to bond out, the court is setting bond in the amount of $1,000. You are not to return to the Gold Coast Beverage. Okay? That's the place where you were arrested. Don't go back there. All right?
All right.
All right. Good luck to you, sir.
Okay. So,
Joshua Broquette, or Brockhurt. I'm sorry if I'm saying that wrong.
Judge, he refused the public defender.
Okay. All right, good morning, sir. How are you today?
What are you?
I'm doing just fine. Sir, you are charged with 1 count of petty theft. You're also charged with 1 count of touch or strike battery, and you're also charged with 1 count of possession of a controlled substance without a prescription. The court does find probable cause as to all 3, sir, to detain you. Bond and as to count 1 is set at $750. Bond as to counts 2 and 3 are set at $1,000 each for a total of $2,750. You are not to return back to the Walgreens where you were arrested, and you are to have no contact with the alleged victim who's a store manager in that store. Do you understand?
Yes, Your Honor.
Okay? Good luck to you, sir. I do find probable cause.
Thank you.
David Lee Phillip.
He bonded, ma'am.
He bonded, all right, bonded. Corinthian Raheem Johnson.
Approach him, ma'am.
Okay. Good morning, Mr. Johnson. How are you today, sir?
Good morning.
All right, good morning, sir. All right, you are charged with 1 count of grand theft auto, 1 count of resisting or obstructing an officer without violence, and 1 count of operating without a valid driver's license. So the court does find probable cause to detain you, okay? Are you following me so far?
A little bit.
All right, let me backtrack a little bit. So today I'm supposed to tell you what the charges are against you, okay? You following me, Mr. Johnson?
Yes, ma'am.
All right, so the 3 charges are grand theft auto, resisting an officer without violence, and operating without a valid license. All right, as to count 1, the bond is $1,000. On counts 2 and 3, there's no charge. Yes,
Judge,
sir?
I can tell the court, I did have an opportunity to speak to him. He was shot in both of his legs. He has a lot of medical issues with regards to that. He has an MRI coming up, I believe it was Monday? Saturday, tomorrow. Judge, what we would be asking, he said that he probably he can't afford the bond. He's single, he's lived here all of his life, he has no children, he's currently not working. He said that the wounds from his legs are actually leaking at this point.
Has he been examined in the hospital while he's there? Has someone looked at him?
Judge, he indicated that he's not getting the medications that he needs in that. So number one, I was gonna ask.
I'd like to enter an order to have someone look at him while he's there in the jail.
Correct, I would ask for that.
So ordered.
But what I would also ask for is if the court would consider RORing him or releasing him to pretrial release so that he can get the MRI done tomorrow, because it's not something they would do. They may not do it at all here, but even if they did it, it would be some time before that would be taken care of.
Okay.
I certainly understand Mr. Farberic's reasoning. That being said, I'm actually going to be asking for a bond increase to $5,000 and a GPS. Mr. Johnson just was released from state prison September 18th of this year. He was sentenced to 10 years in state prison on a 2009, 3 counts of armed kidnapping, 3 counts of robbery with a firearm. There was a second case in 2009 where he was convicted of 2 counts of aggravated battery on a law enforcement officer, sentenced to 10 years state prison.
Right, and he has a new resisting without. Okay, I'm gonna leave that bond in the amount of $1,000. I'm not gonna touch his bond. I am gonna ask for a GPS monitor in the event that he is able to bond out. But I am gonna ask that he be medically evaluated while he's there in the jail, for immediate treatment and medication management. All right, so ordered. State, you asking for anything else?
No, I'm satisfied.
So ordered. Thank you. Okay, Sean Cedric Green. All right, good morning, Mr. Green. How are you, sir?
I've been better, Judge.
All right, Mr. Green, let's see what we can do for you this morning, sir. You are charged with 1 count of petty theft, From the Home Depot, sir.
Yes, ma'am.
State, can he resolve? No, he
It's a felony,
can't. It's a felony, sorry. You cannot resolve this. This is a third-degree felony, sir, punishable by up to 5 years in Florida State Prison. That stated, the bond in this case is gonna be $750, sir. In the event that you are able to bond out, you are not to return back to the Home Depot, and I do find probable cause to detain you. Good luck to you, sir. I'm sorry?
Judge, he indicated to me that he's lived here all of his life, that he's currently not working. I'm sorry, I apologize. He has no money in the bank, but he is currently working. He works at a restaurant here in Fort Lauderdale.
Okay.
His family members are also here. He wanted to know, he's about to lose everything. He's about to lose his apartment and everything. He wanted to know if the court would consider an ROR. If the court's not inclined to do that, if the court would consider placing him on pretrial release standard.
State.
Your Honor, my concern is, he was just released from county jail April 8th of this year. He was sentenced to 364 days on a felony petty theft. That new law offense violated his probation on 2 separate grand thefts that he was also sentenced to 364 days on.
Okay, that's the best I can do for you, so $750.
Your Honor, may I say something real quick here?
Not unless you're gonna,
I'm
wait,
not
wait,
gonna
wait.
talk about, no,
Don't do
no
it.
facts of the case.
All right.
I will not. Okay, he just indicated like I was released, before for petty thefts, whatever. I did 364 days in the county. It was reduced, cause I did the SAP program. Well, since I've been released, Your Honor, I haven't been in any trouble. I've gotten an apartment, I've gotten a job. I haven't gotten arrested at all. I mean, that's over 6 months ago. I got my stuff together. I don't do drugs. I don't drink. This is a misunderstanding. I'm not going to talk about the facts, okay? It's just a misunderstanding. I'm going to lose all that, Your Honor, if I don't get. I can't afford the bond. I have no one to bond me out. I'm supposed to go to work tomorrow. I'm going to lose that job, in turn lose my apartment. I mean,
I
trying to
wasn't
get it
gonna.
together here, Your Honor.
I wasn't gonna bring it up, Your Honor, because at the time it wasn't the most aggravating thing. He was arrested October 23rd on a capias for a failure to appear on a municipal ordinance for resisting without violence. So there have been some issues.
It didn't come in the mail, Your Honor. That's why I missed. It was resolved. The order didn't come in the mail.
I know, but you just told me you hadn't had any trouble in between there. I
Oh,
can't
it was.
No, I know. But that's still a crime. Municipal ordinances are still crimes. You cannot violate those. So here's the deal.
Yes, ma'am.
All right, State. I am. I'm going to reduce the bond to $500. That's $50 to post. You have no one to call for that.
No, ma'am. Your Honor, if you could save my job and my apartment, I won't let you down. Whatever. I'll do whatever it takes.
Mr. Green, now you heard me talk to Mr. Pittman about community court, right?
I'll do whatever it takes, Your Honor.
No, that's not what I'm talking about at all. But did you hear me talk to him about community court?
Yes, ma'am, I did.
Did you get a chance to talk to him at all as to why he could tell I'm very upset with him?
No, I was not able to talk to him.
Let me
I don't
tell
even
you
know him.
why. Because as I
Alright.
tell every single person that comes through community court, you're part of the same village. Remember back in the day, they used to say it takes a village to raise a child? Okay, you're all part of that same village of trying to get better, and I can see that you're trying to do that, and obviously you've hit a stumbling block here, okay? So my concern is, if I put you on pretrial, are you going to be part of the village? You get what I'm saying?
I'll do whatever it takes, Your Honor.
All right, I'm going to put you on pretrial over the state's objection, okay? You do need to check in. He's been on pretrial 3 times before?
Oh, my goodness.
I don't know, Judge Evans.
Apparently, he's been on pretrial 3 times before and unsuccessfully. I can't do it. I can't do it. I'm going to reduce the bond down to $500. It's the best I can do for you. Good luck to you. Please stay out of trouble.
Yes, ma'am. Thank you.
All right, good luck to you, sir. Okay, how about Lenin Antonio Machado?
Good morning, Your Honor.
Good morning, Mr. Machado. How are you, sir?
Not so good. Could be better.
All right, let's see what we can do. So, Mr. Machado, sir, it looks like you are charged with one count of tampering in a second-degree felony proceeding, sir. The court does find probable cause to detain you. Is this bondable?
It is bondable.
It's a first-degree felony.
It's a first-degree felony. It's not punishable by life. That being said, Your Honor, he is out on bond on the underlying offense, which is,
What's the case number?
that is,
I'm sorry?
19,
Uh-huh.
162,
162
CF10A.
CF10A.
It's dealing in stolen property and grand theft.
All right, sir. Mr. Machado, you are already out on bond on a dealing in stolen property and grand theft case under case number 19162 CF10A. The court is revoking bond, sir. You're going to be held no bond as to that case as of today based on this new law violation. Sir, you're to have no contact with the alleged victims in any of these cases. Do you understand?
Yes, Your Honor. It's the same.
Just listen. Don't talk about the facts of your case, okay? Do not have contact with the victim, even if it is the same victim from the first case that you weren't supposed to have contact with again. No contact with the victim. No text, no email, no direct contact, no indirect contact. That means you can't have somebody else contact them either. This is serious, all right? This is a first-degree felony that you're facing right now, all right? So, sir, I revoke the bond. You're to be held no bond. When's his next court date?
That'll be up to his attorney at this point.
All right, so your attorneys will set your next court date, sir. Good luck to you.
Your Honor, if I could be heard
Judge
count
Whitford,
on the
go ahead.
new charge.
Oh, I'm sorry, the new charge. I should give you a bond on this
And,
new
Your Honor,
charge.
what I'm gonna request is the no contact order also include, any other residents of that home, of the victim's home.
Okay.
Family. Your Honor-
What are you asking me for the new bond?
Your Honor, I'm gonna be requesting a $100,000 bond, pretrial release with a GPS monitor level 1, no victim contact. I know the court is familiar with the facts. If I may, Your Honor, briefly, just to lay a record.
Please lay a
first.
record.
Thank you, Your Honor. As you can see, there are allegations that Mr. Machado not only communicated violating a no contact order, but made veiled threats and to intimidate the victims of a pending case, being brazen enough to actually go to their home. When he threatened them to either drop the charges or not cooperate with the pending case. He ended up telling them that, reminding the victims.
I
that
know
he
where you
knows
live.
their-
I understand. I read that.
No, I know you do, Your Honor, and I'm not mentioning.
No,
this just
please.
so you didn't, but that, yes, essentially advising them that if they did not give in to his request, that he does know where they live, and there is a clear implied threat with those statements, Your Honor. I do have a concern going forward, should he be eligible for release for these victims' safety.
All right.
And Judge, I would just ask that, he indicated to me he can't afford more bond than about $3,000. We would be asking the bond be set in the amount of $2,500.
All
He's
right.
already gonna be held on a no bond hold. We're just asking for a bond basically so he continues to get, but he has the no bond hold. He's not going anywhere.
All right, so here's what I'm going to do with respect, like I said, I'm revoking bond, no bond on that other case, but with respect to this case, I'm going to set bond in the amount of $50,000, level 1 GPS monitor, no contact with the alleged victim. Yes.
Just to advise you on a previous case, on William Lomanak, I spoke to Judge Lorenz J. She has already advised Dr. Ludwig.
Okay, so Dr. Ludwig will be, okay, wonderful. Great. Okay, so Dylan William Erb. All right, Mr. Erb, good morning, sir. How are you?
Good.
All right, Mr. Erb, sir, you are charged with one count of burglary of an occupied dwelling, unarmed, sir. Count 2, you are charged with petty theft, second degree, first offense. Count 3, sir, is a misdemeanor capias. The court has reviewed the probable cause affidavit. I do find probable cause to detain you. State what says you has to bond.
Your Honor, I'm going to be requesting a $7,500 bond, no victim contact, no return.
You're asking for 7,500 on count one? What about count two? Oh, well, no, count two is no
I'm
charge.
not asking for anything on count two, Your Honor.
All right, did you hear that, Mr. Farberic?
I did, Judge, if I can have 1 second.
Please.
Judge, he indicated that he doesn't have the money that it would cost for that amount of bond. He has very little money, about $45 when he was arrested. He's currently working. Where do you work, sir?
I work for a towing company,
And how long have you worked for them?
for about 7 months.
And what's your responsibilities with them?
I do towing,
And do you have family members here that in the area that live here?
yes,
And who would that be?
my mom,
Is somebody going to be able to help you post your bond today?
no,
And how long have you lived here in the area?
all my life.
Judge, based on that, we would ask for considerably less bond. Again, he only has about $45. Even if the court set it at $1,000, he may not be able to post that. But I would ask the court to set $1,000 with regards to count one and ROR and count two.
State?
Your Honor, I'm still gonna be requesting the $7,500. This was someone's home at the time it was allegedly committed. He was wanted on a warrant for failing to appear in a theft-related matter.
All right, sir. As to count one, the court is going to set bond in the amount of $5,000. No charge for count two. Count three already has a bond of $500. You are not to return back to the alleged location of your arrest and you are to have no contact with the victim. All right, good luck to you, sir. Tremail Lanot Kelly? All right, good morning, Mr. Kelly. How are you, sir?
Bless.
All right, good morning, sir. Mr. Kelly, it looks like you are charged with 1 count of grand theft auto, 1 count of resisting or obstructing an officer without violence, driving while license suspended, and you were picked up on a misdemeanor capias. The court date for your misdemeanor is December 16th at 9 a.m. That one has a bond of $500. There is no charge for the bond on counts 2 or 3. But as to count one, the grand theft auto, the bond is $1,000, sir. The court does find probable cause to detain you.
Your Honor.
Yes, ma'am.
Pretrial is recommended on revocation of supervision. Mr. Kelly is currently on pretrial supervision in case number 19002930 CFNA. Possession of substitute cathinones and operating without a valid driver's license. He was placed on pretrial on October 29th, 2019.
All right, sir, Mr. Kelly, I don't know if you heard that, but it looks like you've already been on pretrial for case number 192930 CF10A. The court is going to be revoking the pretrial and bond in that case, sir. You're going to be held no bond there. As to this case, sir, because you were already out on bond when you picked up this new charge, sir, this court is going to be increasing the bond from $1,000, sir, to $1,500 for count one, for a total of $2,000 bond and a revocation of bond as to the other case, sir. Your next court date is December 16th. Good luck to you. Do you need me to write something on there? Thank you. All right. Alexander Renee LeBron.
Good morning.
Good morning, Mr. LeBron. How are you?
I'm all right.
All right, Mr. LeBron, it looks like you are charged with 1 count of grand theft, sir. The bond on that is $1,000. On count 2, sir, it's a violation of probation or community control on a felony. Sir, your next court date for your violation of probation is December 16th at 8:30. State?
Your Honor, in light of the no bond hold on count two, I was just gonna ask that the bond on count one be kept in place.
All right, sir, since you're being held no bond as to count 2, we're going to leave the bond on count 1 and $1,000, sir. Good luck to you. The court does find probable cause. Corey Leonard Thurston. Mr. Thurston, good morning, sir.
Good morning.
All right, Mr. Thurston, sir, it looks like you were charged with 1 count of grand theft auto, and count 2, sir, is resisting or obstructing an officer without violence. The court does find probable cause to detain you. As to count 1, sir, the bond is going to be left at $1,000. Count 2, there's no charge. Sir? Yes, ma'am?
Your Honor, Mr. Thurston is on pretrial supervision, case number 19011334 CF10A. Burglary structure unoccupied, criminal mischief, over 200 less than 1,000. At this time, we're requesting a revocation of his supervision.
All right, sir, I don't know if you heard that, but it looks like you're already out on bond/pretrial for case number 19011334 CF10A. As a result of this new arrest, sir, the court is going to be revoking bond and/or pretrial in that case. You're going to be held no bond there. And in this case, sir, the court is going to increase the bond to $1,500. All right, good luck to you, sir. Nope, that goes this way. Do you need me to sign something else? Do you want me to sign that one? No. Oh, okay.
Oh, yes, I'm sorry. I thought it was.
No, sorry. Thank you. All right, Anthony Trey Brasfield Polk.
Yes, ma'am.
Good morning, sir. How are you?
I'm all right.
All right, sir. It looks like you were charged with 1 count of grand theft, sir. The court does find probable cause to detain you. The bond in that case is going to be set at $1,000. Sir, if you are able to bond out, you are not to return to the Dollar Tree. Is this correct? No, that can't be right. No, Dollar General. You're not to return back to the Dollar General, okay? If you are able to bond out. I do find probable cause to detain you. Tony Dennis Mack. All right, good morning, Mr. Mack. How are you, sir?
Mr. Matt?
Mr. Mack? Mr. Mack? Mr. Fabric? Mr. Farberic? Can you
He's
please,
just not responding.
can you step away for a moment, please? Deputies?
Yes, ma'am.
Thank you, sir. I wanted some distance there. Mr. Mack, although you are not responding to the court this morning, the court is, I am looking at you on the camera, sir. You are charged with 2 additional counts of touch or strike battery, count 15 and count 16, sir. Those are $1,000 bonds each. The court, these are add charges. The court finds probable cause to detain you. You are to have no contact with the alleged victims should you be able to bond out. Good luck to you, sir. I don't know when your next court date is.
Let's go. Step out.
Okay. Mr. Farberic, back there? All right, thank you, sir. Zachary Lewis Santiago.
He's a medical reset.
Medical reset, all right, we'll reset that. Victor Huipio. I think you said this was a medical reset? Oh, nope, he's here.
He's here.
Oh, here you are. Good morning, Mr. Huipio. How are you?
It's a blessed morning to see you as well, Judge.
All right, sir. Looks like you are charged with 1 count of robbery by sudden snatching without a firearm, sir. The court does find probable cause to detain you. State?
Your Honor, I'm going to be requesting a $3,500 bond and no victim contact. Looks like he's got a pending trespass. He had a loitering and prowling, resisting without violence.
Is he out on bond on any of these?
The trespass, I'd have to check. He was ROR'd on that originally.
Okay.
Actually, the trespass, Your Honor, he pled out the trespass on December 8th before Judge Murphy. He was arrested on a capias. Came through last weekend.
So he just resolved that case.
Yes. Loitering and prowling and resisting without violence from late April. 2014 burglary conveyance, 2011 burglary conveyance.
All right, defense, you want to be heard?
Judge, yes, he indicated that he has no money in the bank. He had a job up until just recently. He does have all of his family members that live here, and he's lived here all of his life. What we would be asking, you wanted me to ask the court for an ROR. If the court's not inclined to do that, we would ask for standard pretrial release.
State?
Your Honor, considering that he was just in custody over the weekend, resolving a case that he failed to appear on, and now these allegations, 4 days later.
Yeah, I don't know if he's necessarily a candidate for pretrial. All right, so what I'm going to do is I'm going to set bond in the amount of $2,500 as to count one. Good luck to you, sir. You're to have no contact with the alleged victim. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
What's that?
All right, and I think this is the last case on the docket. Abel Garcia Caro.
He is in court, Judge.
Oh, where?
I'd ask you to reset it.
Oh, we will reset it. He's in front of a different
Your
judge
Honor,
today?
is it possible, can we have him maybe brought this afternoon if he's back from court? Just
Sure.
because it's a hyper-technical issue. None of us are going to be here tomorrow.
I'm perfectly fine with
Thank
that.
you.
If he can be brought up this afternoon, we'll bring him back up this afternoon. Okay, and that will otherwise conclude today's, this morning's
He's
docket.
in Conte, by the way.
Oh, he's in Conti? He can appear on the,
If for some reason he's not there, then we'll just reset it. But
okay,
if he's there.
all right. If we can bring him, great. If we can't, then we'll reset it. Before I actually conclude this morning's session, and I'm going to do this on the record and hopefully not embarrass you too much, but you will be retiring as of January 24th, sir.
January
31st? Okay, your wife told me the 24th. I was off. It has been my privilege and my pleasure to serve with you, sir. Thank you very much for your service. Please come back and visit. All right, congratulations. Congratulations on your retirement. Well deserved, sir, well deserved. All right, sir. All right, everybody, that will conclude today's, this morning's session. I will see you later.
Thank you, Judge.
Bye-bye. You too.